Like to mention item 33, ma'am. The concept of the other side is some time to file reply.
33.
33.
Your photo?
State Bank. Respond.
State Bank. Respondent number?
Alert us.
No file.
5 to 7.
Mr.
Take a stand.
Take a stand. Direct photo. Respondent number?
5 and 6, my lord. 5 and 6.
5 and
5,
7. Oh,
my lord. 7. 5,
5.
6,
Uh, How much time?
4 weeks, ma'am. Flip.
With the consent of the other side, may I please mention item 40 and 41, ma'am?
40, 41.
I'm appearing for the petitioner here, my lord. The government has filed affidavit in opposition, ma'am.
You are for a petition.
I am for the petitioner, my lord.
Yeah.
The government has filed affidavit in opposition. Pray for some time for filing a reply.
You are petition in both the cases.
Both the cases.
Mr. R. Sensor for petition. Petition. And data. For respondent number?
5.
5. Okay. File. Both the cases they file. File. Yeah. And get the report. How much time?
2 weeks.
2 weeks time. File. Right. Right. Up. 2 weeks. 2 weeks. Any interim order?
Interim order, ma'am. Both the-
Interim order.
Pleasure.
May it please your lordship. But in today's daily list item number 7, we have
Item number
7, my lord.
7.
7, my lord. I'm for the read petitioner.
Yeah.
Lordship, we have filed one interlocutory application yesterday. So I'm praying if your lordship may kindly call and take up the IA along with today's item number 7.
Interlocutory application.
Yes, ma'am.
For what?
Lordship, after filing of the read petition, certain developments have taken place. And so accordingly, we have filed one representation, lordship, before the consideration of the report.
Let me mention 32.
32.
I have the instruction to withdraw the matter as the party has approached the civil court.
MS S. Roy. When it comes for the petition, where subject my instruction that the petitioner wants to the as he has my intent approach the civil. You have informed anybody? Revenue. Sir. As for the
I beg to mention for listing of read petition for motion, there are 3 matters, lordship. 2 are pertaining to application of force measure under section 168A, and 1 is pertaining to there are 2 parallel proceedings are initiated on the same set of facts.
Monday.
Lordship, on Friday there are some similar matters are coming, lordship.
Monday.
But they are also listing on read petition number 2445 Republic
Subject matter.
for withdrawal.
When
Tomorrow.
you are? Tomorrow.
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 Lordship,
Lordship, I beg to mention item number 3.
3.
Yes, Lordship, the conducting council is not keeping well, so the matter may be passed over for the day.
Miss
P. Agarwal.
P. Agarwal, Attorney Counsel. Waiting for Mr. S.P. Roy, Attorney Counsel for the Roy. And raise it up.
Lordship, this two repetition, Lordship allowed it for listing for today, my lord. In fact, Lordship has allowed the mention for today, my lord.
Not listed.
Not
What
listed, my
to
lord.
do?
Day after tomorrow, my lord. Only land acquisition matter.
Next weekend.
My lord.
What urgency? Tell me what urgency.
Urgency is, my lord, this land acquisition that matter has been referred to the district judge for the compensation award, my lord. And that is fixed on 25th of the next week. So,
25th. Yes.
my lord, can it be on day after tomorrow, my lord?
What prejudice?
My lord.
What prejudice?
My lord, we are the corporation, my lord. We have acquired the land, my lord.
Then what happened?
Against which the private respondent, they have filed a LA case.
Jurisdictionally, what is wrong?
My lord, that process which has been referred to the district judge, my lord, that reference has been is in contrary to that Fair Transparency Act.
Next week.
My lord.
The small aspect of the matter, my lord, the petitioners are the adjacent to that bill, my lord, whichever is settled with the respondent number 5, my lord. Now, in some occasion, my lord, the respondent number 5 used to dry up the bill, my lord. So that's where he used to violate the condition which he has agreed with the
Tie up the bill.
dry up the bill, my lord.
How you are
Yes. How we are affected, my lord. We are affected, we are the neighbors, my lord, just adjacent to that bill, my lord. So we have this cow and all, even the biodiversities are affected if it is dry up. The condition is such that the water level should not be less than 5%. If it dry up also, the water must be at least 5% of the water level should be there. So occasion we have seen time to time, my lord. It should not be so direction, if possible. Direction will be issued that respondent number should not dry up the fishery concern.
respondent number 5 cannot be direct.
Private bill nature. He has got compensation
Private
from
person
the
cannot be
respondent.
direct. What APC can?
Lord, he has got compensation.
Huh?
No.
Page number 29, Lord.
So what is the
That
fair
is wrong.
indirect?
Compensation is wrong, cannot be.
Praying for cancel and also impose compensation on him for erecting dam over.
No, it is a fishery settled by APC.
Yes. We have settled him.
Settlement agreement.
We are not against that, but only to comply with the terms and conditions of the agreement. There is a specific clause also for biodiversity.
Yes, Mr. Sharma. Take this.
Take 38 to
Take instruction. I will take instruction, Lord.
28
And legally, Lordship,
28 to 30.
So for APC is concerned, if there is a question of biodiversity,
Yes, clause 28.
at least you have a responsibility.
we will
Clause
look into it. Presentation is there.
Page 20, my lord, clause 28. The vernacular part. Our English part is not vernacular part. Page 20.
Hard Mr. B.
Lord.
Oh, the representation may be disposed of. That's
Huh?
why
He's taking representation, maybe dissolved. We'll look into it. Lord.
Okay.
Matter instead of keeping
And-
pending.
Mr. P. Sharma. And it's pending now. Assam. For the response number 1 and 1. Mr. As Boba, 19 number, employee institute of raising a fund that the response of five who is a settlement holder of a ticket, has to a bond will mean बहुत secret at Ramkrishnagar Revenue Service, Korimgal District are violating the terms and conditions of settlement of the trading, and as a result, there is threat to the
Clause 7, my page 18.
biodiversity that has been public that John Bean will mean of is a fishery which is settled by the California Assam Fishery Development Corporation to the success user pursuant to meeting of from time to time. After a meeting process initiated by wedding center number tender number 7,000 in comma paid AI on in of game with the paper of the response of five by an order dated 38,000 for a period of 7 according to the petition, pursuant to the settlement order, an agreement was executed between the respondent game limited on one side and the respondent of five on the other side. The fishery has a water area of 400 hectares. The petition are inhabitants of areas in and around the fishery. The petition contended that the respondent of five as per the agreement. Respondent is limited and the respondent of five as per the agreement are required to maintain and preserve the biodiversity of the area by keeping at least 5%, by maintaining at least 5% of the water level and as per clause 7 of the agreement. The respondent authority, the state respondent authority, and are also required to keep the fishery in such a manner that at no point of time the fishery should be dried up. Contrary to such terms and conditions, commander, sponsor, state respondent have been maintaining the fishery in such a manner that during winter season, the water level of the fishery goes below the required norm. It is a case of the petitioner that projecting such highly they have preferred a representation before the respondent number 2 on 1003 taking consideration of the grievance as inhabitants of the areas in the vicinity of as the representative as the respondent number has not acted on the representative of the full finding. Representing of has submitted that in the petitioner have already raised their demand before the respondent by the representative and the and the grievances of the petitioner, the common grievance, the it is raised, it goes, the representative goes, and by directing the respondent to consider the representative stated requirement of the petitioner and after due consideration of disposal by whoever speaking order.
Yes.
Mr. The directive,
In 45 days.
by the management of the view of the plot from right and by the court for court by direct the respondent number of the representative stated to have been submitted by them. Stated to have submitted report on 1,000 and after getting after and pass a in order after getting after affording opportunity of getting to both the side that is submitting side and the side of the respondent side. It is part of the website. It is very useful. We need to do it accordingly or part of the website. But, help come after the the defect of your disorder and a copy of this certificate. We put a phone number by the it is here that the consider that has made it as regards the merit of the name of either of the
Kindly oblige.
Lordship, my senior Mr. Rakesh Dubey is election another court.
Hmm.
Kindly pass about the matter for the time being.
Are you not aware of the case?
No, don't restrict.
Hard, MS,
And be cast.
ND,
And be
Pastor,
cast.
Direct Counsel for the Committee. Non-compliant of the direct mean in order to keep up fast in any in a the petitioners have ever that certificate copy of the order dated 1,000 was duly submitted before the response on 1,000 and the respondent one the respondent had duly access issue notice to the petitioner to
Time being.
Yes, model for Mr. Kodasai.
Except on the last page, they have been asked to explain the delay in file as to why from 2009 they have been waiting to claim the
2009.
Yes.
Oh, no. Huh? Oh, it is 2023.
And the petitioner is in another court.
This is an accuracy method. Also here, I four. Accuracy due to fishing and drowning.
The drowning, Mr. Bharadwaj, cover.
Not
Disaster.
disaster. Natural.
That is, but this is not covered by this. Disaster is not covered by this. This is a notification for 1511. Under this, drowning is not covered. Sail drowning, accidental. There is a difference. Okay, let him come. What is the difference between kill and die? There is a difference.
Die is a natural.
Die,
Kill is by
kill has to be by
act
somebody.
of some other food.
Find out the difference, kill and die. Yes. First you tell me the difference between kill and die. Admittedly, your case is accidental drowning.
Yes.
So it is dead.
Yes.
It is dead. So it is not killing.
No.
Simple.
Accidentally.
Simple. Killing needs somebody else's
Yes.
hand. And if it is a disaster, this is not covered. Come to page 20.
Yes.
Now, kill and die. Now, anything here, it is specifically kill.
It's not.
Let us see.
Yes.
Page 20.
Yes. In notification, it's
Now, what is kill? Anybody,
by the other.
anybody else
Yes.
had killed you?
No, there is nobody
Oh,
there.
This
Accidentally
kind of
drowning.
decision, just because the government has framed a scheme. This is not to be entered. AL. There is a difference. Kill and die. Anywhere? Let us see.
No.
Criteria. Kill. Clause 1 kill. Clause 2 kill. Clause 3 kill. Due to accident in public places or in public places. Kill. We entered in the other repetitions because somebody else's vehicle killed him. Is it not? Where is now?
But Lordship, some of cases has been held by this honorable.
No,
court.
I'll go by dictionary.
If any person died in a public
Any
place, that is lake,
death is
river, etc., they are also
Oh.
in it.
I don't think.
So Lordship, kindly grant me time
No grand crime.
for those.
This kind of petitions are coming unnecessary. To cause the death of a person. Animal or other living. One of them. Okay. Yes, kill versus they die.
I'm trying to figure out.
You may have yes in disaster management, but not under this.
Yeah.
Never. It cannot be. Somebody goes to the fishery or river, got drowned,
But-
and every day government will receive 100, minimum 100 claims. Is it a policy? Extremist violence, firing by security forces, communal ethnic group cases. The concept is the death was caused by somebody else. If you give it such a broad definition, then suicide will also be covered. Yes, anything you have to say? I told,
Lord, kindly allow me 2 weeks time.
no, to,
I filed
no. Till tomorrow.
Look.
I don't find anything to enter in. Nowhere it is, tie is there. On the prayer of Mr. Messiah, I can't learn it. Please take it. More.
keep your
Yes,
Very much. Number 2.
victim compensation.
Yes.
Yes.
Already awarded or what?
All of has been awarded. Unfortunately, the payments are not been able to be made because of the possible
Oh.
funds with the state legal
Fund
support.
grant.
Yes. I have in fact filed
Yeah.
an affidavit on 29/4.
Yeah.
Yes.
Yes.
Heard Mr. Messiah. And one, five. Am I sure you represent
Respondent number 2, Your Lord. I am
only two?
only
One, three, 4, and 5 MSR ASLSE for the petition has been uh, they demand that the petition has not been paid. An amount of it 5 lakhs towards final compensation under the provisions of the Assam Scheme Compensation Scheme Commercial Health Care Commercial Benefit and Maturity and Training ASLS by referring the affidavit in opposition. Referring the annexes annex to affidavit file on behalf of the respondent, has submitted that the district legal service authority the respondent number 3
Yes.
has submitted that the application preferred by the petitioner has already been registered as A sub B sub C sub M sub number with 2000. The respondent number 3 after completion of query, has awarded an amount of rupees 3 lakh as final compensation to the victim by an order dated 24/7/2020. But due to non-availability of but the payment could not be disbursed. Statutory has further referred to a public interest in PIL number 7/2024, which is pending presenting before the division bench of this court. The subject matter of PIL is non-allocation of sufficient funds to the ASLSA from the state exchequer for disbursement to the victims under the Victim Compensation Scheme 2012 as amended. So it is further submitted that till the year 2023, an amount of rupees 9 crore is yet to be disbursed by the state government. And as a result, the legal service authorities are experiencing fund crunch for disbursement of the compensation under the Victim Compensation. If you notice, returnable on particular date. What is the other date?
Lordship, that is fixed on 20th, next Monday.
No, PIL is next Monday.
No.
The other day you on another repetition.
Several repetitions I have had. I
Okay.
apologize. 2 weeks or
Issue is returnable. Returnable also.
one
Three weeks.
small,
3 weeks.
not 9 crores, is still sanctioned. 24 crores is the requirement.
Okay. Yeah.
As per the
A
order
large amount, a substantial amount.
mentioned in
14. As doing so, get accepted. No problem with this. Extra copies we need. Considering the fact that the PIL it's ordered to be listed on 20/05. Any this is the outcome.
Republic.
I have taken instruction regarding vacancy position. One post is blank. He has submitted that 4 are blank. It's only one position.
Out of 70.
So I have also taken instruction through my client. She has been informally informed that some post of these are also within.
Yes, what is your submission with the position?
I leave it to your lordship.
Don't leave it to me.
My lord, 17 posts comes above 0.5.
In fact, lordship comes to page 43
You
of the
file your affidavit
My lord,
at the earliest. At the earliest.
I can file. And my submission is subject to outcome.
at least one post may be kept. If the post is filled up,
Any process is going on.
That instruction I don't.
any moment the process may start. At least one post may be kept taken. Others can become instructed. In fact, if lordship comes to page 43, I just want
No, I understand, but in the process there are some other issues also. It is not that just that is the ground. Because your mother, all these aspects are there.
That was
And this date occurred in 2015. Maybe the ground of rejection is one thing, but on the face of it, the ground is bad. appear.
Lordship, while rejecting the mother's application, the observation was made that whenever a fresh application may be made again, there is an observation in that MP note, that order will be considered freshly. Come to Lordship.
Not a large establishment. That is what
Yes, sir. Page 30, Lordship.
you have recorded everything. Page 30.
Yes, sir. However, second,
I put it under subject to further.
Lordship, I have written in paragraph 9 also, I have got all the educational qualifications
Right, right.
required for this post. In fact, grade 3 also. At least one post, Lordship, that may be kept vacant, Lordship.
So
Otherwise,
your case was considered under grade 4.
Lordship,
Grade 4.
grade 4, Lordship. I'm not doing grade 3, Lordship. Grade 3, there is already one professional appointment is there, Lordship. And there are 29 posts, it comes to 1.45, Lordship. There cannot be two. In fact, that grade 3 appointee is also now transferred from there, Lordship. He is not there, but still I'm not.
Hard to detect. Uh, in fact, and up. Right. And then it subject and then there is one post, one it the establishment of one member having regard ground of the of the it is common for the purpose of the next is observed that in the set of the are regarding and I will conflict between the response for it, response by their conflict and conflict except again
All right, I live. It is item number 7.
Yes, my lordship, this case, my lord, it was listed earlier also, before Honorable Justice Sanjay Medhi.
I-
He recurs in taking this case.
Huh?
He recurs in taking this matter because
who is the state bank?
bank, no.
Bank.
Copy was served.
Yes.
This case is that, my lord, that the petitioner has taken a housing loan from Punjab National Bank of 28 lakh, and out of which initially he was paying, they were paying the installment well, but after some time due to COVID and other thing, he was suffering. So he could not pay the installment in time. Accordingly, the account became NPA, and the account.
So
was
what relief can be granted in such situation?
Now I'm telling, I'm coming, my lord. Why I filed this petition? If a doctor goes to the impugn order, my lord. This is first, why I filed the impugn order against page 84, my lord. 84, order dated 3/4/24. Nodal officer for certified bank appeared, Land Council for certified data probability. Land Council paid for more time to deposit a remaining amount of loan. Land Council of City stated the city is agreed to pay all its dues, including interest and cost within very short period, and city has already paid 4 lakh. Record shows that after execution of eviction order, CD has filed a petition which he submitted that enter loan with interest and cost will be paid up to 10/11/23. Considering the petition filed by CD, recovery officer passed an order dated so and so in which he directed CD to hand over the keys and evicted flat. But CD has not paid the entire amount loan till. Again, CD has filed a petition and also affidavit dated so and so, which he promised to pay the entire loan amount with interest up to 31/3/24. Considering CD's petition and affidavit, land recovery officer has given one more chance to a city for deposit entire loan amount and cost up to 30 lakh. But instead of depositing, all it do, he has deposited only rupees 4 lakh on 27/34. Lana Council paid for only 30 this time for deposit entire loan amount with interest and cost on the ground of city poor health condition. Considering the poor health condition city and his intention to pay entire loan amount with interest and cost, last chance for deposit entire loan amount is given to city. Failing which, their property will be taken against under physical possession of land tribunal and inter cost will be borne by the city. Order. City is directed to pay the entire amount within 35/24. Number 2. City are directed not to sell the property without permission so and so. Number 3. City is directed to file payment report. Number 4. If city will not deposit the entire amount with interest, property will be evicted without receiving fresh eviction notice, and eviction notice that is already served upon the city on 10/3/23. 6/7/5/24 for filing report by CHB. So before 7/5/24, I filed this petition before the Honorable Court. But since the Honorable Justice recurs in taking this petition, in that petition, what I have stated in my prayer is that to give me something, this is my only dwelling house, and my daughter.
Right, all these are taken note of.
Huh.
But what to do?
No, I'm coming, my lord, I'm coming. So last chance may be given to some resume time may be given, and the order may be stayed.
Show me any recent decision of the Supreme Court.
No, I'm coming, my lord. After that, what development? That's what I have filed this IA. That IA. Since the order has not, that matter has not taken up. Since the matter has not taken up before in the appropriate time, the date is already fixed before the Nallet Tribunal. So I am filing under no other alternative remedy. I have deposited out of 18 lakhs, I have deposited 18 lakh 70,000. I have deposited 15 lakh. And order, the input order is like this. So only 2 lakh 70 is balance remains as per statement account. As per statement account, Annexure E, 24 page. First para.
You deposited what? 4,5 lakh.
4,5 lakh.
Not 6,5, 10 lakh.
Yes. So I have
Total
deposited,
balance 4.80 lakh.
so I
There are
deposited
95 plus 6.
Annexure C, page 21 is the last order passed by the recovery officer on 3/5/24. Nodal officer for certificate holder bank present. Land account will appear for certificate data availability. This case is filed as per application filed by C. Nobility Kunti by the city has submitted a producer order test 3/4/24. He has paid rupees 15 lakh. And he has, among other things, also sought further time 6 months for prepaying the entire amount of thing amount. See, the director
I think
submitted
presence of the bank council should be, bank council should be there.
left bank.
All Mr. Ganguly is there as per the previous order. Because Mr. Mitra, you are aware, otherwise jurisdiction is very limited.
Yes, I know.
It is, since they have got substantial amount, I think it is, all is in their court,
Yes.
basically. So something has to be expected out of him. Let him come.
We'll call it now.
Call. Yes, Mr. Sharma was
Communication has been sent, but we are yet to
no point keeping it pending otherwise.
dispose of it.
Let him take a call, Deputy Commissioner.
Hearing both the parties, sir.
I have already recorded your
Yes,
case.
sir. Yes.
Paragraph 3.
Yes.
It is cancellation of next up.
Yes, sir.
You have sent it by post or what? Yes. Representation, annexer,
Annexure 9, sir.
any receipt when the stamp is illegible.
26th of February 2024.
26th of February. Yes, Mr. Borua, page
64, sir.
stamp is legible.
No.
Below. But there is some stamp.
Personally, I think.
There is some, I don't know,
Huh?
2024 I can make out some.
Anyway, he can take it.
If at all he has submitted, definitely
Otherwise, sir,
We can do that.
we presume that he
You will submit a certified copy along the copy of the receipt.
yes, sir.
because that is his claim that he has submitted. If at all it is submitted,
Hard, Mr.
Emma.
Ahmed. Yeah. Yes. Mr. Ahmed. No, no, perfect. You. Please. Come on. Mr. Borua, and what pay for that. Later. I've already people that are point number
Respondent number 3, my lord.
comma, the secretary, the considered after reporting of both traffic and not have it direct comma, the both direct uh, comma, by and had you know and acted by no on it's board
Four, Lord Chief.
under on board and dispose of it by order of support big board of getting to both site or record uh, record big to dispose of the representation comma submitting just a certificate of the order and copy of the if that is of it if you don't take it and three there copy letter as X comma certificate edit of name content ways of a name of email number
Yes,
uh, no,
Lord, may kindly give a time frame, Lord. Time frame,
45 45 after date of
yes, sir. High level.
But I think he is within DRT or something. So can you take on Friday?
Friday.
But it,
But
last time,
make it morning you make it from him.
I
that
will
he can
inform
come.
him, so let it be listed on Friday.
It is basically it is a back authority.
Yes, yeah, because but last time at least he should be present because the name is
Yes.
shown.
On the Mr. S. Mitchell and Comfort of Commissioner is present. However, they got to be done in count for a respondent by German bank. Let the case along with the IA. मैं petitioner. My lord, the issuance of my lord patta, my lord, the petitioner are in position of the lane, my lord, that the patta has been issued, my lord, illegally issued, my lord, I asked you to bring something more. Yes. My lord, I have, my lord, my only limited fare is just, my lord, it's getting all this fact. I have submitted a representation before the deputy commissioner. Only, and my lord,
But I am not satisfied with your fact. That
Hello.
is the other one.
Hmm.
At least I have derived some satisfaction that this is a case which can be disposed of.
my lord,
The representation can be disposed of. I am not yet satisfied
my lord, not
that you have a legal right
my lord, I
to ask for disposal of a representation.
my lord, to cause an inquiry because my lord,
Right. But I will not direct to cause an inquiry just for the sake of it at the drop of a hat. First, I have to satisfy myself that yes, there appears to be a case
let him
that
get the
petitioner has some legal right.
my lord,
If
I'm
in
in the
this manner, if you file representation, if representations are disposed of just to make an inquiry, then everything will come to a standstill.
I just pray for my just let him
Come
get
up with better
get
document.
my lord, my lord, the person in whose name the my lord, the patta has been issued, he himself my lord, submitted an affidavit that he has not my lord, applied for any patta and the petitioner are in possession of the land.
What is your position?
My lord, that is my lord, agricultural land, my lord,
Gaon Pradhan issues documents like this.
that he
We
has
are not satisfied with that.
issued a certificate, man. And that's my lord,
The Jamamati, your name is there.
my lord,
The records of right.
my lord,
The Jamamati.
my
The
lord,
Jamamati, you have an act.
my lord, that in the name of the my lord, the persons to whom the patta has been issued, definitely they are.
Where is your name?
My lord, that is my case, man. The patta
That
has
is
been
your
issued.
case. I am not satisfied.
My lord, only my humble submission is that.
Make effort and I am not satisfied. Why should I direct
lord, just-
inquiry just for the sake of it? I am
my lord,
not satisfied with your credentials.
my lord, only my one submission.
Make an attempt. I am not.
My lord, that legitimate just for a moment, there is the affidavit that has been my
After
lord,
hearing today, I am not satisfied.
on that, my lord, there is no on that,
On
there is
that
no
date, I have heard you. On that
signature.
date also, I heard you.
My lord, that is on that, my lord, the signature, my lord, inadvertent, my clerk is not submitted. So can it be just, my lord, for any, my lord, the limited period, that, my lord, that maybe let them get the instructions, my lord. The person,
Now, if you insist,
no,
I
not
have to
insisting.
pass the order.
No, I am not insisting. Only my humble
I
prayer.
am not satisfied.
Because, my lord, in whose name the patta has been
Have I made myself clear?
Fine.
Or
My lord,
not clear?
my lord has, my lord, because this my lord, patta has been issued.
Right?
My lord, just
Okay, you
my
start.
lord, only for a moment, my lord, that I just
I have given you moments for 2 days.
my lord, only just I want to draw your lordship kind attention as regards the
Since you are insisting,
No, I'm not insisting, my lord, just my
okay,
lord,
okay, continue.
on page 30, my lord, page 30. Page 30, my lord, that is the affidavit, my lord, shown by this person, my lord, in whose name, my lord, patta has been issued. Parikshit Sharma, he says that he has not never.
On that, we'll say did not constitute court
Man.
act
Man.
on a document
My
of
lord
a
is
private
correct.
party.
My lord is correct. That's why only my prayer, my lord,
Leave it
let them get-
aside. Leave it aside. Anything more?
my lord, and my lord, that is my lord, they have not made any my lord, demarcation prior my lord, issuance of patta, and my lord, there is some restrictions that if the my lord, land is my lord, adjacent to the highway, that the patta cannot be issued. My lord, the land is my lord, adjacent to the high court. My lord, is stating all.
Mr. Das, when you are feeling your effort to establish legal right, at least some indication. We are not into PIL.
No, my lord is correct. My lord, correct. That's why my lord, only my prayer is
On
that,
the
my lord,
prayer of Mr. B.K. Das, Land Council for the petitioner, is the case of until
my prayer was that my lord,
okay then. Third time,
my lord, oblige.
giving time. half an hour is allowed. Whatever, not half an hour is allowed. After, okay. My lord, I put
May this the petitioner is occupying a plot of land, common plot of land. Ultimately, eviction was done, Your Lordship, during the pendency of the earlier writ petition. Notice was issued, Your Lordship. He came before this honorable court, and his honorable court refused to pass an interim order, however, directing the authorities to consider my representation for settlement. And during the pendency of that writ petition, Your Lordship, I was evicted over a plot of land in which we have been residing since around 50 years, since 1970. Now, Lordship, and now, Your Lordship, during that, Your Lordship, we withdraw that petition, Your Lordship, and file the present petition, Your Lordship, on seeking, Your Lordship, rehabilitation from the government, Your Lordship, in the form of an alternative plot of land, Your Lordship, plot of land, and that
if their policy they will come up, we should not be
Lord,
Right.
on the basis of 2019 land policy.
Yeah. Or
50 years from 1970.
alternate on seeking rehabilitation as part of exam that has been
Zip.
Similar matter, sir.
similar or what?
Similar matter, sir. Because they
Any order earlier?
Your Honor, page number 210, Your Honor.
Page 100?
210, 216. But the final order has been passed. Final order has been passed.
Okay. The final order kind of
Yes,
page 100, 211.
200, operative part is
Art Mitra,
SS Gupta.
Yes?
SS Gupta.
SS Gupta. Direct counsel for the he has got a thing. Central government council. For the number 1, Mr. S. Can. And it's central council. ECS.
226.
came under section 73. Final order has passed on
15/4/2024.
15/4.
2020.
Right. Right. Is 213 right in the order?
Yes, sir.
Through Rocket method, the Kupata method, a proto plan method, measuring 3 bigger 2 kata, 2 testers method, that revenue village got test Mozara, revenue circle college body in the Kamru. Here method, they are active method by the water method is 33 method. It is later method, it is by the extent and a method. Here method proposing to evict the petitioner method. They are proposing by this water method is 33 38 method. A modern. It is issued by the state officer and a relay method. By this water method, they are proposing to evict the petitioner method from the plan.
No, proposing not this notice.
Method.
Notice.
Yes, notice.
Notice. Saying that you are unauthorized.
Unauthorized.
That is there.
Yes, right. Now, method, change the petitioner method, that land method, they have been occupying a total plan method from the date of the forefathers method. And I had submitted some receipt method or revenue.
So why don't you contest?
Method, now method, although method, they had accordingly in terms of this water method, the
See, Mr. Hawk,
method,
you have a claim of on a plot of land measuring Pata land, 3 bigha.
Right.
And they have served you notice. From the jurisdiction point of view, whether this authority has the jurisdiction or not, has to act as an asset officer.
method, if it is public,
my
public
question.
that if it is public property method, then they have the jurisdiction. But it's not public property. It's how method, test 26 method, that land method, earlier it was Exonia method, test 26 kindly come.
No, you have a claim, you are a valid patadar in respect
Yes,
of
ma'am.
3 bigha plus land.
Right.
Now you have been served in
Right.
under section 4.
Right.
Right. Now they claim you are occupying their land.
Right.
They claim.
Right.
You are claiming, no, I am occupying
Yes.
my patal.
Yes.
Now what business?
Method, they are visiting their houses, method, they have
Is there provision to submit a reply or not?
method, they had submitted requisition method.
Is there any provision?
Test 39 method. Test 39 method on the same date method, they have appeared before the state officer method. Test 39.
This kind of
No method,
one paragraph without any
But,
document.
method.
Mr.
they had-
Mr. Is
they
it a
had-
reply?
They had produced documents method. The state officer was not in a position to hear them. Ultimately, they had to submit this method.
Why, Mr.?
This is a wrong assumption, Lordship.
No, there is a
Under
formality,
formalities, there are
procedure,
procedure,
for leading summary evidence.
Lordship, Lord.
Now,
It's a
and Mr. Gogoi, sorry to say, most of the time, they act very hard.
after a notice, the purpose notice, Lordship, is here it is also says that Lord, you have to adduce evidence. Lord. After that, Lordship, the section 5 notice will be the premature matter. Lord. Till today,
Absolutely.
Lordship,
Two parallel procedures.
Lordship, the
But-
premature matter.
Mr. Gogoi,
Lord-
still, they act very arbitrary. They simply dismiss the case. And pass order under 5. But there is a procedure.
Procedure is there, Lordship, but a procedure after section 5, it should be, Lordship, we were there 2021.
There is one more 2008 one.
2000
That is the problem.
Lord.
We can observe when that
Lordship. Otherwise, also, Lordship, I am here. The purpose notice. After that, section 5 notice. After that, you also get opportunity under section 9, Lordship.
right, but there is a procedure that both sides can lead evidence.
So here in this case,
It is not a case
Lordship.
that the railway should lead evidence first.
No, Lord.
Petitioner can lead evidence,
That's
or
why.
otherwise, railway can lead evidence. Whatever. It is not that like a trial. Prosecution and defense. These are
Yeah.
these are we will only observe, Mr. Gogoi, but
Yeah.
we find that at least they have a claim
They have a claim.
to contest.
I also admit, Lord, they have a claim, Lordship. So they have submitted the documents, Lordship. On the basis of that, Lordship, now we are not proceeding. As because although he has not annexed the documents, Lordship, although he has not stated in his petition, Lordship.
No, Mr.
After-
Gogoi, what I am contemplating is that what is the procedure as laid down in
It
the
should be
Act,
followed, Lord.
the estate officer should follow.
Should follow it.
And otherwise, this repetition is premature.
Lord.
But at least we'll give the procedure.
Lordship, that's what I am not.
Then we'll close it.
Lord, we
Because
close it on-
thereafter he has provision for appeal
Lordship,
before the
appealing
district
is
judge.
there, like,
He has all the provision.
all the
This is
strict prescription
A
is there.
misadventure otherwise.
Lordship, Lord.
Tomorrow. As talk.
Sir.
Okay, Google.
Tomorrow.
Otherwise, other matters we can take.
Oblige.
May I please, may I please, your Lordship. Lordship, the impine order is at page 19, Lordship. Whereby the respondent number 4 was appointed, here's the terms of the advertisement.
High Court counsel?
Lordship,
High Court hasn't been made a party.
Lordship, Judicial Department,
No. High Court.
Then
It is also High Court.
Lordship allows me to amend with the hand and fix any other date.
District and session judge, you is served. The respondent number 2 and 3 will be represented by the High Court counsel.
I'll serve a copy.
There is no rule. Mr. D. Dekka,
Yes.
counsel for the petition, has submitted that he will furnish copies to the learned learning counsel. For respondent number 20 by today.
Yes, Lord.
Can do it today. Can proceed on Friday.
Right.
Otherwise, this is
Of 21/3/2000.
listed for
Lordship, Friday. I'll serve it
from
copy.
Monday.
Lordship, I'll
I'll
serve
not
the
be
copy today. I'll serve the copy today. It is
Please, yes, on Friday, reflecting the name of the learning council.
highly obliged.
It's fine. So this is a petition where, my lord, if your lordship kindly see. My lord, the petitioner here,
Central tax.
my
Tax. Which day?
My lord, he had submitted, my lord, all his returns, my lord, and everything, my lord, and his, my lord, file was put up for scrutiny. That was for the year 14-15. 14-15. And my lord, when it was put up for scrutiny and for reassessment, my lord, he preferred an appeal on two grounds, my lord. One ground was that, my lord, while my lord preferring that reassessment, he was not given a notice. And secondly, that exercise of reassessment was barred by limitation. And accordingly, my lord, in pages 30 to 35, the Joint Commissioner had set aside that, my lord, saying that he had not been notified and that the exercise for reassessment was barred by limitation. Now, when it was set aside, then, my lord, for the purpose of preparing that appeal, my lord, he had to make a pre-deposit, my lord. And he had to make a pre-deposit of 25% of the amount.
No, the appellate authority already
Decided.
That barred by limitation.
Barred by limitation, and that, my lord, he was not notified.
Set aside.
Set aside.
Proceeding is set aside.
Proceeding set aside.
Okay.
So that, my lord, his assessment, whatever was submitted, so that was accepted. Now, my lord, because for the purpose of the appeal, he had to make a pre-deposit of 25%. And
Why required?
That is required under the Act, my lord.
Why appeal is required? Already set aside.
No, that is set aside, my lord. What I am saying is, for the purpose of that appeal, which has been preferred by the dealer,
okay,
pre-deposit had to be made, my lord.
You did not deposit.
I deposited. I deposited at around 11 lakhs and odd, I deposited.
Okay.
Then, my lord, when this order was set aside by the appellate authority, I made a representation for refund of the security deposit.
Okay.
And while, my lord, that sanction for refund was sought for, then the Commissioner of Taxes passes this order at page 41, my lord. And 41. Kindly see the, my lord, subject.
Okay, refund.
Yes, ma'am. Resubmission of proposal seeking approval for sanction of refund, rupees so and so, to Mr. New Hubjan Tea Company Private Limited, so and so, so and so.
For proposal of
So now, my lord, when this proposal for refund was given for a second time or a third time, then he says that, my lord, this record does not contain the order of reassessment, and that is why he is directed to reassess the account and audit for the period 14-15, my lord. The second paragraph I have read about 2 or 3 times, my lord.
I am not very English is very tough.
My lord, I am also not being able to make out, my lord.
It is very tough.
My lord. So, my lord, on the basis of this,
Gogoi can explain.
Gogoi will able to explain, my lord.
I will also have to see clarity.
On very it is not found of the
Second para is something about
and third line also. The connection between second paragraph and third paragraph. First paragraph also.
Right.
It appears that a proposal for sanction or refund when under the complete is not complete. And then what happened?
Now, my lord, they are again seeking to reopen the files and continue the reassessment, my lord. That is why I am before your lord. Because
when everything has been wiped out from existence,
my
from when this appellate order, you are not challenged.
No.
Mr. Gogoi has to challenge. Yes. If you are agreed by the appellate order,
yes, my lord.
it is for you to challenge. Now, the appellate authority has wiped out everything by the order from existence. Now, how can you revive this? Because I don't know for the English, but otherwise, something was not there, but you complete the proposal.
My lord.
For necessary sanction, perhaps. Then the subsequent authority perhaps initiated.
substitute judge for 7 days time. It's Friday next week. So it seems that the assessment order has been set by our appellate. The assessment now.
and then notice. We'll keep this notice event. Notice this notice are what? Page annexure 8?
Yes.
8. 9. 9. Then page 45 also.
Page, my lord, it is annexure 8, my
Annexure 8.
page 43, 44, and 45.
Ah.
9 is, my lord, given by me.
9. Right. Okay. Then what is the next one?
These are all, my lord, given by me, man.
Okay.
Annexure 8 series is required to stay.
Then, Mr. Find out dot theta methane till then. No corrective action terms of this dated 37. Take your instruction, maybe.
Yes. Let me separately.
Get the exact explanation from paragraph. Third. This should turn it on. And for the all the
All right.
for all the committee we did. Who was I think? Who was? A registered dealer.
Each dealer registered dealer.
No, under
At the-
that,
yes.
that was
Was.
the petitioner who was a registered dealer under the Assam value-added tax, 2000, was assessed was not to be assessed for what?
No, my lord. He had submitted his return. And that was, my lord, accepted by the assessing authority.
For the year 2015, that's
14,
2015, uh, on submission of the return before the
assessing
authority, subsequent the case of the petition was reopened for scrutiny for the year 2014 by the respondent assessing officer in the year 2020, right?
Yes.
The state process ended before the appellate authority state process terminated before the appellate authority, that is
Joint Commissioner of Taxes.
Joint,
Yes, Joint Commissioner.
that is the Joint Commissioner of Taxes Appeal Command, who by his order dated 30/12/2000 had allowed the appeal preferred by the petitioner inter alia on the ground that the assessment order was barred by limiting the subsequent period. After the appellate order, command of petitioner sought for refund.
11 lakh 20,000, which the petitioner had submitted as the amount for a people. Correct?
My lord.
Correct or not?
Yes, sir.
However, uh,
The Commissioner of Taxation,
that page
41. Special Commissioner of State Tax, Assam.
however, the by not dated 11 and asked them to complete previous the sailing of the as it has been asked, has been served with a bit of aid by the deputy protocol. I had it from uh, next Friday. Next Friday. Well, next 24 5.
My lord, that order dated, my lord, at page 45, 27 2. Let me kindly be mentioned.
Which one I have?
You have mentioned, my lord,
3011.
yes, 3011.
Followed by another notification 27 and to produce record. As it primarily appears that the appellate order dated 12 has reached the effect of there cannot any court defect against the petition. Court by
May I please? My lord, the petitioner has challenged the lord order that you find page 35.
35.
30.
Yes.
Now, since my lord, petitioner is my lord, not a government employee, so this my lord, the bar imposed my lord, to the petitioner, not applicable.
Yes. Huh?
They have judged the applicability of the rule over here.
There any rule? Rule
Yes, rule is
Paragraph,
there.
paragraph
Rule is
11,
not,
your lord.
rule is not in favor of the
Until
To update instruction regarding.
no, these model rules are to adopt it, be adopted.
But-
To be adopted.
to be adopted.
If not adopted, not enforceable.
Yes, but this letter, my lord, page 35 has created.
Activity to be time regarding adopted.
Oh, no, it is a law point only.
And they have done.
Law point, nothing else. Nothing else. Law point. You are not in the way culture.
My lord, he's not well today. Even though
Not
I am
well.
not well today, my lord.
Whether these rules are enforceable.
Yes, your lord.
Huh?
That's why I need to update my
Because-
lord, whether
Now, why you are agree?
Because he's my lord, 66 years of man, my lord. So he's affected by.
And who are the parties involved? Official response 1 to 9.
they have wrong.
Who is this response number 7?
7 is my lord, Thakur, my lord, new secretary.
Already appointed.
Yes, already appointed.
And you can only issue notice.
Lordship, they have written that they have made a
You can only issue notice at least.
Lordship, in the respondent, they have made a mistake. 1, 2, 3, 4 serial numbers, my lord. Response number 5, they have quoted twice.
Third, Mr. And it also put up the MS Burwala MS S box, SK box,
ST box.
SK box. Corporation number 3. The it is the case of the that he was appointed as second of Method Lalu Omaba corporate the petition is the case of petition. The employer-employee relationship existed between the site and the but the state response have framed a set of model laying down the terms of employment and work for the employees of the cooperative society, which are required to be adopted by the respective registered cooperative. The with this response, the petitioner is aggrieved by a letter dated 1/2024, answer 7, issued by the respondent of 6, in fact, wrongly mentioned by Foster as response number 5, whereby the society, members, Justice, Mobile Home Limited has been asked to release all secretaries. Release by the chairman of all the registered corporate have been asked to release, have been directed to release all secretaries aged 60 years and above, and to appoint new secretaries in accordance with the model rules. As the petitioner is aged above 60 years, 66 years, the petitioner presently it is 60, above 60 years, yes, as the petitioner is above 60 years, he has been unilaterally released already. Yes, released. Unilaterally released by the respondent. Right? Following the direct made in the order date the model have not yet been adopted by the respondent to input side. So in any way of the matter, the state respondent have no authority and jurisdiction to frame model rules, laying down the condition of terms of employment, working conditions of employees of cooperative society, and to direct them to adopt as a registered cooperative society is an independent entity, and it has the and such a registered cooperative has the prerogative to determine the terms and conditions of employment for them. Right? This is your case. Return. And for weeks, that's when now the petitioner file amended outside for the in today's draft of the area of the 1 to 6. One is by Buddha, 2 to 6 by Moth, petition subject for the 7 7 green bracket correct, right? So I raised that to the petitioner has submitted that the number has already of the respondent to input, right? It is observed that the appointment subject out.
But he has not handed over the yet. And each salary also unpaid for a particular year, 2008 to 2060, the arrear salary.
That is, we cannot direct it.
But
right now.
This judgment at page 33.
How you die?
Yes. She the deceased went for a bath in a particular nala where she made accident and she died. since it is a public place, so he is under the cover of the circular, or people find at page 15 is circular. And this notification has been dealt with by in the judgment and order that is fine.
Here the state has initiated a process. They had admitted the case. Here, we, they have filed an affidavit. Paragraph 7.
Yes.
6 and 7. Mr. Nag, you here? Or
one paragraph page for paragraph.
consider the process of dispersal was already taken up. That was the case there in counter evidence. Otherwise, the concept view of the court is that Hill and I are two different things. Hard. It is easy as good. It is 1-5. Oh, yeah. Easy also. You are take care of. MS at what? 5 here.
uh, in that in terms of 11,000 on the point of it, commented 30, comma, price due to dropping on 5,000. Extra couple. Okay. Yeah.
Please.
Yes.
In this case, my lord, in this case, my lord, admittedly the respondent authorities misplaced or tampered, my lord, some official documents, my lord. This is an my lord.
Misplaced.
Misplaced, my lord, page number 30, my lord. Recently, my lord, they have stated, my lord, another records, my lord, draft Chita volume 3, my lord, and original
Yes, Mr.
has been
Ahuja.
displayed.
Shall we issue notice?
My understanding 42.7.
Similar persons, my lord, already approved before this court, my lord, page number 21, my lord. 41, my lord, 41. Court has already granted interim protection.
Exactly same. Exactly same.
My lord, exactly now, my lord, we are claiming, my lord, original Chita volume 3 and draft Chita volume 3 has been also missing. Therefore, my lord, we are the apprehension of eviction, my lord, and therefore, we have the genuine.
Your credentials are same or what? Page 41.
Page 41, my lord, this is also, my lord, also same. They are also playing, my lord, some records have been misplaced, my lord.
Same Moja.
Same Moja, my lord. Same Moja, same contact.
This is 44 TS.
My lord.
So here in case of response number 758 or what?
8, my lord.
Part Mr. F.
FL Oscar.
FL Oscar. Here also. Part for the one. The PKBT. Junior government book. Huh? Digital PK and petition name petition name here owners of different parcels of land in village Mad village village Sondipur Gran it is the case of petition that the entire and record pertaining to Moja Sondipur Gran Alga district Hailaka are either tempered to or damaged under the custody of the of the petition have further made that the lands their lands are Pata lands and they are possessing it is the time of their forfeit. The petition have made an apprehension that collision which the respondent must be the lands of the petition are sought to be converted to tea garden land and their eviction are being contemplated. And Mr. As referred has submitted that similarly situated petitions have already approached court by way of the and those petitions there the interest of those petitions is protected by equipment charge notice returning as extra the petition that makes for service by registered within few of the alert transport part are also part of the considering the position made by the that here but does respect of land under their is provided that will the return comma the petition cannot be evicted without due process of law.
May it please the petition, Lordship, the petitioners are tenants under the Kabirsan Committee at Atta. Lordship, they have been paying their rents since around 30 years back, from around the mid-90s. Lordship, in regard of petition number 1 and as well as the other petitioners, they have written agreements as well as oral agreements. By way of agreements, the relationship was formed, and till date they have been paying monthly rents, Lordship, to the committee. Now, Lordship, in the year and Lordship, the committee, Lordship, is taken is the charge is taken over of the committee by different dispensations. Lordship, in the year 2018, a committee was formed, and Lordship, that committee, Lordship, they seek to evict the present petitioners who are tenants under them by different means. Lordship, in the year 2018, Lordship, a petition was filed, a PIL, by making a frivolous allegation that there has been encroachment in the land. Lordship, although the PIL was disposed of because the court was not inclined to enter in the PIL, however, a view was formed by the court that the public PLTC, Lordship, a committee has been formed which will look into such matters. Lordship, maybe, Lordship, after passing out the order, Lordship, maybe the committee had approached the authorities. Therefore, Lordship, in the month of January, Lordship, on Lordship 24th January, Lordship, a notice was issued, Lordship, in the month of January 21, 2024, Lordship, which is Annexure 4 at page 60. Here, Lordship, a notice has been issued to all the petitioners, which, Lordship, refers the petitioners as encroachers, Lordship. Lordship, if I may read, Lordship, page 60. This is to inform you that the date of hearing for encroachers of government land covered by dark number so-and-so under Moza Guwahati has been fixed on 25/1/2024 at 12 p.m. Lordship, the petitioners were informed to be present with sufficient documents. Lordship, the petitioners were present. However, now, Lordship, the petitioners, Lordship, they are aggrieved because they have been termed as encroachers. Lordship, and the fact is such that the government land was allotted to the committee, to the Kabristan, and the Kabristan committee had rented out the premises to the petitioners. Lordship, if at all there has been an encroachment, Lordship, it is the Kabristan committee which will have to be evicted, Lordship, not the petitioners. And Lordship, if the Kabristan committee is of the view that the petitioners they don't want to let out the premises, they can take recourse to the Tenancy Act, Lordship.
No, whether that Kabristan is a government land or something else.
It is as far as the petitioners I've been informed, it is a government land allotted to the Kabristan. Therefore, encroachers will be the Kabristan, not the petitioners. And petitioners are wrongly referred to as encroachers. They have been paying their rent. Lordship, the petitioners also made a representation to the concerned authority, the district commissioner, the GMP authority.
So otherwise, the circle officer, he is statutorily empowered exam and to take action under the Assam Land and Assessment to evict any encroacher from public land. Kabristan land is admittedly the public government. So you have been asked to appear just because you have been termed as encroacher. That otherwise.
Our case is that if they want to evict, they'll have to evict the Kabristan first.
Why?
Because the Kabristan has been allotted that.
You are living right under Kabristan.
Lordship, we are paying our monthly rents to the Kabristan, Lordship.
If your case is that Kabristan has done wrong, then how can you shelter under the Kabristan?
Lordship, if we have to be evicted, let them follow the due process under the Tenancy Act, Lordship. Because this is a litigated procedure which they are.
Tenancy Act applies under government land.
Lordship, in the Act, there is a provision, Lordship. Tenancy Act of 2021, Section 3. Act not to apply to certain premises if the number sees premises owned by religious or charitable institutions as may be specified, but by notification by the state government, Lordship. Lordship, if there is a notification, then it may not apply.
The topsil, the schedule, Sohor 1, first part, government diagram 143, Kabristan land. So it is government land. Okay. But Tenancy Act, whether Tenancy Act is applicability of the act. for landlords and tenants.
Your Lordship, the relationship of landlord and tenant is Your Lordship established because the Kabarstan Committee has been receiving rent. If Your Lordship may turn to page 47 or page 45, there are receipts, up to date receipts.
Now, how can this act be applicable in respect of larger issues? How act can be made applicable to government land?
Lordship,
Admittedly, it is a Kabarstan Jami and Sorkari Dak,
Lord-
government Dak.
but Lordship,
How can this be
under
applicable
the
in
Lordship,
government
the
land?
definition of landlord is another Lordship, is any other person. Lordship, a juristic person, the Kabarstan can be included.
No, no. Question is for seeking your right, to protect your right under this act. Now, whether this act is applicable in respect of government land,
Because the land
this
is allotted
is
to
an
the
act to
government.
decide dispute between landlords and tenants, right? So here the land for definition is there, and this is regarding tenant, subtenant, and all. It is question of occupation of government land.
Lordship, we are not occupying, we are simply
No,
tenants.
firstly, the larger issue, you maybe with relationship
Lordship,
of a tenant with Kabarstan Committee, but larger issue is that it's a government land.
Lordship,
Right.
if, Lordship,
Whether this is applicable,
Lordship,
if
even
a government takes action, whatever, that they are of the view that our government land is in encroachment, then the act, Assam Land and Regulatory, those are applicable.
Lordship,
How
then
can it be
even the Kabarstan will have to be affected by the government in that case. If there is encroachment, the
That
Kabarstan,
is, it is not that
because
it is a
Lordship,
case
we are
of
paying rents to the
borrower
Kabarstan.
guarantor. They can approach their lands are in occupation, unauthorized.
Lordship, because the
This notice is that they have found this only the unauthorized occupation of government land.
Lordship,
How
then,
can
Lordship,
this,
then let the
I don't think this is applicable.
Lordship, then let the government initiate eviction process against the
But
Kabarstan.
you have
Lordship.
to establish your right.
Lordship, my right is that Lordship,
I don't think
Lordship, my right is
it
that
is
we had
somewhat illegal.
Lordship, we
Why
came
not?
into agreements with the Kabarstan.
This government land, it is a government land, whatever, Kabarstan, whatever. Anybody who is in occupation of the land without any permission from the government, they can evict. Like you may have created a tenancy with the Kabarstan Commission, but the question is that you are in occupation of the government.
Lordship, that we
Then the owner is the government. Then Assam Land and Regulatory Settlement would all come, not this land.
even otherwise, Lordship, this notice, Lordship, should be set aside. Lordship, let the government
How
initiate
can
proceed
this is notice?
against the
This,
Kabarstan, Lordship.
you
if
have
they are
asked to
encroaching.
appear along with documents.
Lordship, that we have done, Lordship.
Then
Lordship, Lordship, this relationship of
you
tenants,
cannot presume that you will be evicted.
Lordship, because we have been termed as encroachers. And we are not encroachers. Because we have been paying rent to the Kabarstan.
No cause that you are not encroacher.
Lordship, that we
How
have
you have
done. Lordship, in fact, the representation was submitted before the concerned authorities on 28th of February. Lordship, that has not been, Lordship, considered to date.
circle officer is the and it says that everybody will be hurt. Ask them to appear along with all the and admittedly it's the government act. He has the authority and jurisdiction.
But allotted to the Kabarstan.
Whatever, he may decide whether to correct or why.
Then,
Ultimately, it is government land.
Then, Lordship, if these petitioners are removed, Lordship, the committee will, they'll rent out the premises to some new persons, Lordship, in that.
Those are under the terrace check. The larger issue is it is a government land.
Only, Lordship, our grievance is that we should not be evicted as encroachers. And if at all any encroachment has been, then it's done
So
by the
this
Kabarstan.
fill the doubt of the circle officer by producing documents that you are not an encroacher.
Lordship, that has
This
been
is
done.
just only in the form of a so-called notice.
Lordship, that has been done. We were present, we showed the documents. The representation was also made before the concerned authorities, to the circle officer as well as the district.
Let them decide. let them decide how can we run a parallel book. It is not that you have come at a premature stage.
In that case, the direction may be made to the concerned authorities to at least pass a reasoned order, Lordship, against the representation, because nothing has been done there.
Yes, Lordship, in the
Yes.
agreement, and there are nowhere it is mentioned that the government is now.
Coborster is not down.
Yes, sir.
Coborster has not been settled
Yes, sir.
the land. Coborster has been allotted the land.
Allotted the
There is a difference between allotment and settlement. Yes, Mr. Nayak. Yes, but instead of deciding, allowing them to decide how not. You may have a tendency vis-a-vis their Coborster committee, but so far the land is concerned, had it been settled with a Coborster committee, it would not have been government land, right? It would have been a Coborster committee would have been the patadar. It is not the case that they are settlement holders.
Our grievance that we are not encroachers. If at all encroachment
Right.
has been done, it's the Kabarstan, Lordship.
Decide. Let them decide.
One phrase that Lordship till disposal of the Lordship representation, Lordship, no eviction, Lordship, maybe.
So, look, your apprehension is that before deciding your
That we may be evicted.
Hard.
People.
keyboard was council for the petition. Or you can take instruction what is the fate of this. What is the present state of the proceeding? Can take it very well from response number 4. Circle office. Monday. Present stage of the proceeding. Whether any order has been passed either in favor or against them. Right? MS. So now you're for one. One is S Borua or
one. Yeah.
One. Can you go ahead? One. And it is the case of the there is a support and now one. And the state same is managed by the corporate one that is the further and around and comma they enter and take it with the corporate fund and their comma they are running their from the state government. The petitioners with a notice by the response of 2001 by the response of by the state command of it. I mean, asked to appear before the state corporation along
supporting document. So, the notice says that on the premise that there enclosure of a government plot of land under diagram of 143, comma, Sohor 1, part 1, in bracket, Koborska. In response to the state command of petition have already submitted, appeared before the state or before the respondent of court and have already submitted the document at their disposal, which go to support, which according to them, go to support their claim as regards tenants under the point number 8, that is the allot of the same government bank number 143. Apprehending that the respondent of without consideration of their claim, petitioner's claim, they would be evicted from bank number, government bank number. They have approached by which as a petition stated that approached by the 2001
2001
have been brought calculated, as regards the present status of the by the against the petitioner have rejected Monday or within for state
tendency may not be a bar, Lordship.
already decided, okay, already decided, and will be say that the conclusion after affording opportunity of hearing.
Extract.
Okay, MS
Madam, my passport for the time being is Mr. FZ Muzuna was here, but he moved.
Please proceed. Proceed. Pertaining to the enrollment of the petitioner Sean Malot. Malot. Next are 2 Malot, page number 18 Malot. Yes, who are the response number? What are the responsible authorities? Yes, Malot, CDC. Response 2 Malot. CDC.
You can. I can accept.
Anybody is there?
Yes,
Specific
it is
standing
allotted
counsel.
to Ujjwal Kumar.
He is standing counsel.
No.
This is the this unique identification or what?
Yeah.
What about the access notice on behalf of unique identification or what?
Yes, sir.
That's one or two,
Is a grievance that Aadhaar card has not been issued. Otherwise, grievance is not very superior one. So, he just kind of
Plus 10 months.
class. Parents already have Aadhaar card.
Already have
Sister, younger sister also has Aadhaar card. Somehow or other, he has not been done. That is a. Can you take it? From which authority?
not that's one or two, my lord.
One number, oh, three perhaps. Perhaps
Three, my lord.
Yes, Mr. Purva can test it. He is a student, not taken. Aadhaar card is not his parents. His younger sister, aged about 8 years, have already got the Aadhaar card. He applied.
In 2019.
That is your case.
Yes.
You passed it or passed the exam or not?
Exam pass, my lord.
Exam pass.
Non-issuance of the unique identification number.
Aadhaar card.
Aadhaar card. So ultimately, that would be the union government. So they come up with.
Oh, they have an authority here. Response number
2. Deputy Director General. Yes. But there is also the chairman of UDI.
Number 6 is also, my lord.
The deputy
Enrollment agency.
is the agency who undertakes the job, but ultimately it has to be given from the union government, that Deputy Director General. So we can just coordinate with the authority to find out.
So you data instruct what stays has been stuck. All of you appeared for at the same time, or what?
Counted in 2019, my lord. It was applied, my lord.
Okay, furnish copies to MS Purva and Mr. Purva. Extra copy, 1 copy, he will take instruct first.
HP new.
Sir,
HP new.
HP.
New.
And MS S Purva. And I will S Purva. And 5. Itu tuh harus sama ayo sama and apply for other and appear the other
11, 6, 2019.
come to academy 7
9.
ayo sama and I will also capture by taking identity also the the other number has not been the committee killed it. And the court MS Purva. It is different from the response number 3 and the response number and thought for next Friday. Yes. Mr. Neil transport of the front of the street of sector. Mr. Mitwa and Mr. Boy during the course of today.
I can where you put the on after the murder of his daughter lordship, like person then the dead body was murdered, the dead body was hanging.
You approach under 153.
But for fighting of the affair, the police has not the proper investigation.
So, what to do now?
The lordship in this regard, the petitioner is a
Representation
fifth generation
SP.
before the SP.
Then, what to do now?
Till that lordship, the petitioner's statement is not recorded.
So, art Mr. Anna. There is a procedure, Mr. Ahmed. This kind of repetition is not to be entertained.
Several times they approach the IO lordship.
Okay.
And which direction
MS as Purva. For all that. It is the petitioner that by the the following procedure. Where is your FIR?
is 10.
In connection to it, the date of the petitioner's daughter. Under suspicious circumstances, the petitioner lodged a first information report against court officer in charge of her justice on 10/3/2020. Against 5 number of accused persons. Merito. The in the state affair, the petition had alleged that his daughter was killed by the accused person by hanging her. his car and the accused person had their protect rights as to check. On receipt of the state FIR command of her it registered the same as FIR for the offense and for the offense and the rate and entrusted the investigation to a sub-inspector of police W. Sub-inspector commandant of her. It is the further case of the to the affair has been taken and the to investigate, the investigation has not been carried out in a proper manner, alleging lackadaisical investigation by the IO of the case. The petitioner has already submitted to the Superintendent of Police, Mumbai, on 23/2024, seeking his interference in and to carry out a fair and proper, fair, proper and proper in the case. As the Superintendent of Police, Mumbai, has not taken any standing action on the basis of the state as by the president seeking inter area related to the response authority take immediate and necessary action in connection with the case where and after investigating the matter and arresting the person, to submit a charge under the provisions of para. It is settled that uh, uh, as per the provision in the Code of Criminal Procedure 97. If a person has a demand that the police station is not registering fire under section 154 here, then he can approach the superintendent with the section 143 here by an application. Right? Even if that does not give the sense that either the FIR is still not registered, or that even after registering it, no proper investigation, is open to the active person, file an application, but CRPC before the jurisdictional magistrate. If such an application under 6(3) CRPC is filed before the jurisdictional magistrate, the magistrate can direct the FIR register and also can direct a proper investigation be made, in a case, where, according to the active person, no proper investigation is being made. The jurisdiction magistrate can also, under the state provision, monitor the investigation to ensure a proper investigation. It has been observed by our reported that the power in the border 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 under 6(1) big here independent power. And exercise such power command application or magistrate can ensure a proper investigation, and it includes the power to order it has been observed that if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police, he can direct the officer in charge of the police station concerned to hold a proper investigation and take all such steps that may be necessary for a proper investigation, including monitoring the same. And I can also feel that if a person has a grievance that his FIR has not been by it has been further observed that the High Court should discourage the practice of filing a writ or a petition under Section 4 here simply because a person has a grievance that his FIR has not been registered by the police, or after being registered, proper interest has not been done. So for such grievance, the remedy lies and one big code of conduct, and if that is of no avail, one big code of or by filing criminal complaint and not by filing a deed petition under Article 20 for a petition on the voting. Since such a writ petition is discouraged and a jurisdiction magistrate has the authority and jurisdiction to ensure proper investigation in a case like the present one, the instant petition is not emphatic, reserving the liberty to the petitioner to seek redressal of his demand before the jurisdiction magistrate under Section 1 here.
It's a weird situation I have come, my lord. I had purchased a property, my lord, in 2019. And whatever happened, my lord, cutting the story short, my lord, in 2024, when the bank officials came and inspected the property and they said that they are taking symbolic possession, I came to know for the first time that that property was engaged, mortgaged, and they will be proceeding for auction sale. In the meantime, my lord, sale deed initially was not being registered. A lot of hanky-panky was going on so far as the owner is concerned. He took the loan, he did not inform us. He sold us the property, took a lot of money, and thereafter sale deed was registered in 2020. Now, when the bank officials visited, I gave them a representation saying that part of the property, that is the second floor and the terrace, that has been purchased by me and I am the registered owner. But since there was very short time, my lord, they proceeded for the sale, and that sale happened in 12th April 2024. Now, to save myself from the situation, my lord, the only option that I had, my lord, that my husband, my lord, he participated in the auction, my lord, and earnest money to the tune of about 8 lakhs. Ultimately, that the husband has purchased the property. And after I filed the writ petition, they were also pressing on the sale money to be given. And that sale money has been given and the sale confirmed and sale letter has been issued. Now, my lord.
So your husband was the auction.
Yes. Now, my reason for coming before this honorable court is that after the sale agreement, this part is over, my lord, so that this technical part is over. Now, so far as my situation is concerned, 2019, I entered into an agreement, and whatever he took the money, my lord, and thereafter he was not executing the deed. Now, he never said also that it is mortgage, maybe because he knew that he cannot sell it. And while my husband is not away, my lord, before the execution of the sale deed, I was given possession of the property, and the seller, my lord, he persuaded that, okay, this thing will go on. In the meantime, you can build up the area. Only the floor and the ceiling was given. I spent money and all the walls and everything and all kind of family relationship, good relationship going on till I invested the money. And thereafter, when my husband is not there at night, my lord, they will make weird and sounds, my lord, and try to create fear psychosis and things stolen away. CCTV was installed, my lord, for my safety. They removed the CCTV. They would disconnect the electric connection. In 17 February 2020, I lost an FIR. That is at page 59. And in spite of the offense communicated in the FIR was not registered. Thereafter, this continued in January 2022. Another FIR, they did not register that FIR. On 17th March 2024, another FIR, they did not register the FIR. Now, I have come here with twofold, seeking for twofold relief, madam. One is this FIRs, there should be investigation, and why they have not registered, this is one question, madam. And secondly, madam, so far as the sale money is concerned, the bank has taken the money. Now, what they will do, my lord, after adjusting their cost, the dues to the bank, the residue money, they will release it up to the borrower. Whereas, my lord, here is a case, my lord, because of the sale deed, since half of the property at least was my property which the bank sold. The whole money is not entitled by the borrower, my lord. But if there is any delay, I have deposited yesterday. They will release it today, tomorrow. They will release the money, my lord. I will have no remedy left, my lord. I will be remediless.
No, how your owner of that photo,
Owner is actually
you
I.
entered into an arrangement with him. You paid money to him.
Yes.
You paid money to him, not to the bank, perhaps.
No, not to the bank.
In the auction process, you paid to the bank.
Yes.
Now you want to recover, or you are claiming some part from the residue on the basis of those which you have given to the landowner, who was instantly borrower of the bank. How can you enter?
My lord, that I cannot claim, my lord. My lord has rightly pointed out, my lord, that I cannot claim. But my property which they have sold, half of the property is mine. So my property money, you apportion the money, that my property
Yes,
money.
well, where is the scope in a read proceeding only?
My lord, without read petition,
There are other forums.
there are no forums left, my lord. I exclude all,
Otherwise,
my lord.
make a claim before
That is also
These are
barred,
not-
that is also barred, my lord.
by part.
That is because they proceeded under the SARFAESI Act. And civil court is barred from interfering in.
Otherwise, proceeding is misconceived.
My lord, perhaps not, my lord.
Apparently misconceived.
My lord, perhaps not, my lord. For the reason, my lord, when the borrower, what the borrower mortgaged was that seller's property. And what the
Why should we enter all these disputed questions?
is not disputed, my lord. Is
No,
the,
no, no,
if
no,
no one is disputing that
This appears to be misconceived.
my lord, perhaps not, my lord. May kindly consider, my lord. Kindly consider, because I have a registered sale deed.
Proper forum would be different something.
My lord, I'll place the SARFAESI, my lord. There's a categorical bar, my lord. So
Let us share of the sale proceeds the petitioner with respect to her share of property. All these are.
my lord, my share,
Why
my
should we
property.
determine all these
My lord,
disputed questions of?
there's no dispute, my lord. No one is disputing. There's a registered sale deed, my lord.
We establish it.
My lord, there's no
Get
one
an
is,
injunction.
no
or
one is disputing, my lord.
order from the tribunal.
My lord, in a tribunal also I am not entitled, my lord. The tribunal, my lord, I'll just place the provision, my lord. Section 13,
In any view of the matter, even if you place,
my lord.
I don't think you have any recourse here.
My lord, I do not have, then I am remediless, my lord. In the writ petition, I am seeking remedies on the, so far the bank, not as the.
So far, your registration of FIR is concerned, that is completely a different story altogether. Already I have held, and it is a settled position of law, that you state that the FIRs were lodged,
My lord.
nothing has been registered,
My lord.
and you have set over the matter. Now, next recourse is already laid down in the CRPC. So, for third period is concerned, you have to be.
My lord, that because I can avail, my lord. But so far as this is concerned, my lord, 13, my lord,
Which provision?
my lord, for 17, my lord, 17, which is the appeal provision. Right to appeal, my lord, has got 17, my lord. Any person, including borrower, agreed by any of the measures referred to in subsection 4 of section 13, taken by the secured creditor or his authorized officer under this chapter, may make an application along with such fee as may be kept the DRT having jurisdiction in the matter within so and so days on which such measures. Now, if only that agreed person agreed by any action taken under subsection 4 of section 13. Now, if I may just take my lord that provision, my lord. Subsection 4 of section 13. In case the borrower fails to discharge his liability in full within the period specified in subsection, the secured creditor may take recourse to one or more of the following measures to recover his secured debt, namely, take possession of the secured debts of the borrower, including the right to transfer by way of lease, assignment of sale for realizing the secured debt, secured assets. B, take over management of the business of the borrower that the best so far the borrower, bank is concerned. Then C, none of them provides any provision for a person of a situation like mine. Because only 13.4, anybody agree under 13.4 has a right to
What are the procedures for auction?
my lord?
What are the rules?
Sorry, my lord.
Procedure for auction?
Procedure for auction. That is enforcement of secure section 8. My lord, we made the enforcement of security interest from section 13. Notwithstanding anything, my lord, notwithstanding anything contained in section 69 or section 69A of the Transfer of Property Act, any security interest created in favor of any secured creditor may be enforced without the intervention of the court or tribunal by such creditor in accordance with the provisions of the Act. When any borrower is under a liability to a secured creditor under a security agreement, makes any default in payment, in repayment of secured debt or any installment thereof, and his account
What is the provision for returning the money?
for returning them so far as the residue is concerned, my lord. One is subsection 7 of this section, my lord, if I may place this or this also, my lord.
Which?
Subsection 7 of section 13.
Subsection 7
of section 13. Where any action has been taken against a borrower under the provisions of section 4, all costs, charges, and expenses which, in the opinion of the secured creditor, have been properly incurred by him or any expenses incidental there shall be recoverable from the borrower, and the money which is received by the secured creditor shall, in the absence of any contract to the contrary, be held by him in trust to be applied firstly in payment of such costs, charges, and expenses, and secondly in discharge of the dues of the secured creditor, and the residue, my lord, and the residue of the money so received shall be paid to the person entitled thereto in accordance with his rights and interests. Now, when this person entitled to, my lord, my entitlements come because part of the property I am the registered owner, my lord.
Make a claim before the secured creditor.
My lord, that
Make a claim.
my lord, I'll do that pending that. Let them hold it in trust, my lord. Under section 5 already provision is there. I will do that, my lord.
Under subsection 7, make a claim.
My lord, I'll do that. Till then, they may hold that. I'll do that immediately.
I appear for the respondents 5, 6, and 7. No copy has been served by the fact that the interim order has been sought against us. As far as section 13, subsection 7, the person entitled thereto has to be determined. The authorized officer of the bank has no such power or any authority to determine the entitlement of the person. In case of any grievance, either the tribunal or the civil court.
Right, that is my privacy view, because we are not here to determine all these factual
My lord, this
issues, factual
correct,
disputes. We are not here.
I understand.
Whether you registered sale deed, whether agreement for sale of land, whether you paid money, whether you have not you paid money, whether you have entered into an agreement, who will decide?
That we decided. That I'm the registered owner, my lord. That's this document, my lord.
restitute of money
But-
to receive shall be paid to the person. In fact,
And
there has been
there
acknowledged
too,
in
my
fact.
lord.
So, I think remedy is before the tribunal only.
My lord, I cannot go before the tribunal only
That-
under
that
subsection
court-
4.
Might have inherent power also.
Subsection 4, my
We
lord.
said also on the issues arising out of subsection 7.
My lord may dispose it of with the provision that I will approach the whichever forum this honorable court considers. Until then, at least let them hold trust, my lord.
No, if I have not entertaining the writ, then how can we,
My lord, subsection 7, my
that the
Sub-
that shall not be dispersed?
subsection 7, my lord. Subsection 7, they have to give it to the person entitled to, and they are saying they are no one to decide.
These requires factual determination, madam.
It does, my lord, but there has to be some forum to decide it, my lord.
The tribunal will be based.
Tribunal will not do that. But in the meantime, they will. My lord, it does not say that the tribunal. Section 17, my lord, specifically says that only person who is agreed by any measure taken under subsection 4 can approach the tribunal. My lord, I am not saying
So
that.
in any view of the matter, this proceeding is misconduct.
My lord, this honorable court may not do. I seek just this much, my lord, that
No, which we think which is not, cannot be passed.
if this if in this writ court it cannot be entertained, then DRT under the it will follow the statute, my lord. Here
Okay, you argue that.
my lord, I just
I have heard you enough.
I'm seeking just some mercy and remedy.
These both remedies are not found to be entered.
My lord, subsection this
Firstly, these are disputed questions of fact which do not
I'm not
like to entertain.
not the
Prayer 1 and prayer 2. Prayer 3, there is separate proceeding. This kind of petition is to be not to be entertained. Prayer 3. Settle law. Already I have dictated 1.
It's okay, my
Now
lord.
I'll
It
dictate
can
1.
go down whatever will come, my lord.
I don't.
Just
You
that
lost an FIR 2000 sitting over without any further action. Right? Thus, you have completed the formality of lodging the FIR for the officer. Now, after 4 years, you have come that my FIR was not raised.
pointing out the fact.
No, the
pointing
prayer,
yes, it's my prayer
have to-
also.
I have to also look into the facts
Yes,
and
yes,
the prayer.
It's okay. I understand, my lord, but the police
See, this
when there is
factual determination, this is not the proper.
I'm not seeking a I know that it cannot be factual decision.
No,
cannot
you
be
want
taken.
to relate section 7 of 7 of 13 plus something which you have entered in a private contract
Yes,
with the borrower from the bank. You want to connect both the two.
because they have sold my property, my lord.
Now-
And
now-
they were in
now,
this. I'm
Question is,
registered
is it falls under the realm of public law or in the realm of private law?
my lord.
We have to decide in a writ petition first.
The bank.
First,
Yes.
right?
Yes.
This connecting thing is out of the
My lord, the
public law.
bank
realm.
is not a private person, my lord.
I know.
And
It been only bank. Yes, I could have said. But here you want to connect your transactions with somebody else with the residue,
I'm not asking for
with the residue amount, right? That is what
yes.
you want to connect and secure a part of it. Is it not?
In a way,
You want to connect those events with the residue.
even if we forget the events, my lord, if I minus those events, my lord, the fact remains that I am the registered owner, and my lord, their due was around some 45 lakhs on odd. My lord, they could have sold half of the property which I am not the registered owner. Even they could have got the money.
So, did you raise all this
Yes,
as an option
yes,
purchase?
yes. Before the auction, I raised it. Before the auction, I raised it.
raised it?
Yes.
They will give consideration, whatever is there.
Under section 7, till then they decide my lord only that much of protection, my lord. I know that I have my limited. I'm
Yes, Mr. Ganguly.
So my instruction is yes, that we have authority already, and we are not the correct authority, my lord, to cite question of type. But you will notice, my lord, that even the amount that petitioner is claiming is not quantified. There's no quantification of the amount. So the authorized officer, my lord, is merely performing his functions under the act. He is bound by those rules and as they are. Any remedy, my lord, that they have to seek in the civil court or in the DRT. And their remedy, my lord, if I may speak, is against the private respondent, not even against the bank. That remedy, my lord, either the civil court or the tribunal can decide. We cannot decide.
My
Connecting thing that the petitioner's private transaction with regard to that building or whatever floor and with the residue, that what of the
We can discharge only the statutory encumbrances or costs and etc. Bills, taxes, those we can discharge as an authorized officer, not beyond.
but to what my
no,
friend
we
is
have to
saying,
examine, madam, in that 226 also, whether it falls under the realm of public law or private law.
my lord, this
Here it is apparently
This-
it is the realm of private law.
this answer, it is not private law, it is public, my lord. To this, what my friend also says, my lord, that it cannot be quantified, my lord. That is an incorrect statement made because when they gave a reserve price of the property, my lord, they valued the land, they valued the building,
No, question is not that.
my lord.
Question is not that part of the question is the arrangement or agreement, whatever you have made with the borrower
Give that
and
away, my-
connecting those
I give that
with
away,
the residue to claim a part of the residue is the issue.
my lord.
If I am not wrong from your side.
My lord, to this, my lord, I will just I rephrase my submission, my lord. To this, I say, I am not saying that calculate my money, what I pay to them. That I understand it's a private contract. But my second property, second floor and the terrace that you sold, which is I am the registered owner, you have quantified the value of the building. When you quantify, you take the value of the property, the land, everything. My property, you don't, you.
Is it an issue can be raised here, which you are arguing?
My lord, I do not have remedy under the Surface Act.
All these valuation kind of thing you have to raise before tribunal.
Well, the tribunal only
You
submit-
participated with your eyes open in the auction process.
but it was like just a flicker of the eyes, my lord. And there was no time, and I gave my representation to them before the auction, my lord. My lord will relegate me to the forum, my
I
lord.
cannot relegate. I cannot relegate.
My lord will not dismiss it without any observation, my lord. Otherwise, I will be remediless. And my lord may consider one thing as a
You can only observe that this is not found to be entered.
since I'm invoking a discretionary
But
relief, my
I will exercise the discretion.
uh,
I have indicated
my lord,
enough.
a person who has played fraud, my lord, let him not be the
We are not here against any private person. Do not issue any writ against private person.
yes. That is why when the bank, my lord, the public,
Bank has committed any fraud.
my lord, bank has committed the mistake of selling my property, although it will
Okay,
not.
Mrs. Quill, I have heard you enough.
I
I have entered
yes,
into enough.
my lord, I rest, my lord. I'm paid.
Right. MS.
In
Yes.
fact, my
Correct. Council for petition. MS. Correct. And taken and council for the number. The facts needed. Yes. The facts. Proceed. Okay. In the year 2008,
approach the uh, to and up equal and comma repetition. Agree. But what do you put?
My lord, I just have the question again.
What do you put?
I purchased from the, now I have purchased the whole property from the bank, but from that seller I had purchased the second floor and the and 50% of the sale.
Where did you make?
It is 30th September 2020, page 38 is the sale date. And mentioning I have done it in page 7. Sorry, paragraph.
Budget. Second floor. And of under contract are situated at a plot of land maintaining for covered by a partner, comma, a sub the effect, comma, the petition and the response of like that. Agreement of state on it by house. It is case of a that initiate the petition of a sample 14 seconds out of the concrete and agree at 27. Subject, comma, subject, the balance amount of paid the response of the petitioner has that during the subject, comma, the response by it is the for which the petitioner had lost trust and is put to the petitioner has stated that the state despite losing effect, the same was not considered
as a like complicate and reference number were not provide no the complete way further down in that Maya demand by them to find it from a safety was registered, executed, executed between the people on site and the after the owner of the second floor of the parking construction had been completed. The petitioner further stated that he had lodged another fire report at the cookpit on 21 August. It was the on topic that the responsible had taken a bank loan, a loan from the responding bank, Punjab National Bank, on in the year 2000 mortgage the subject for with the responding bank. When few bank officials from the other or the other branch of the paid a fee to the subject for and form the petition that you had fault made by the the bank had taken up input of the subject and the billing then had the respondent bank authorities had thereafter initiated an auction process by publication of e-auction notice by fixing the valuation of the landed property in subject at rupees 45 lakh 41,071.19 plus further interest and other charges. It is a case of the that of the initiation of the auction process, the petitioners legitimate purchase landed property that is the second of the so the auction process the husband or the participated in the state auction process and state of he became the successful bidder at rupees 85 lakh 50,000. after the husband of the previous comma deposited take amount like lakh 50,000 and the response had still confirmed on 94,020.
Happy have the sales certificate of it, my lord. Yes,
Yeah. Oh, it is a further case of after purchase the property by the registered date, date 24 in 1000. The petitioner has made substantive construct the second floor of the RCC from their I mean from their end and as a result, the property should have been the valuation of property should have been more. As the respondent bank authorities are required under the provisions of subsection 7 of section 30 of the Securitized Construction Act to disburse the residue of the money received the auction process after meeting all the other structures, mentioned herein, to the person entitled there in accordance with his rights and the petition has is under serious apprehension that the entire residual amount will be disbursed by the respondent bank authority. The respondent number 8 and 7, as they are the borrower in the books of the respondent bank, stating that the petition has no other limit stop the respondent bank from disburse the residual amount to the respondent by number 9. The with the seeking the following the first belief that has got is apportioned of the state received by the Reserve Bank of and thereafter to disburse a share of the respective amount to the petitioner commensurate with her share in the property which has been occupied. The petitioner has also sought indirect to the corresponding authorities to register the first information report, the first information report, which the petition had lodged before the at the district station on 7 comma 22 and 7 as regards lodging of the FIR are concerned, comma, the petition silent as regards subsequent act taken by her after the act of alleged non-registration of the two FIRs, comma, stated to have been lodged on 7 and on 21 respectively. Employees well settled. As about the procedure, as about the limit available for a person when a person who lost by or to her is not registered by the officer in charge of the if a person has a given that the is part of the code begin bracket 1 here begin and bring it to 154 fine. When it that does is a strict does and effort or that enough for my by 1 6 detail before the you can have such by before the such that effort and also comma in a case where comma got so property the alloy is by the in like reported And one more. Sudhir Bhaskar of Namde versus Hemant Biswant Agge another voted 2-7 for very different uh, following the from the in Sakib are uh, voted very very voted the same time observed that that super second of by the comma of the authority now even I the approach for data 1 comma 6 has become first grade and the it's found that the husband has MR has succeeded in the auction initiated by the Bank of for realize its use that approach of that. And your deposit of the entire auction amount, comma, the respondent bank authority for it shall come from it to the husband of the wife. So as a result, the landed property is of, comma, the property as of in the landed and the amount should subject has been has auction by but so far as the claim regarding care in the under as part of the 7 of the Bhattacharya where any action has been taken against the which an auction for comma all
opinion of the dispute market. Punjab having property by 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 them by or any expense is to be recoverable shall be recoverable and the money is by the secured creditor shall in the absence of any contract or contract held by near trust apply first payment of the cost charges and second discharge of the secured creditor and the receipt of the money entitled in accordance with right. What is the valuation?
They have that
It transfers.
85 lakh.
Hmm?
They had that 85 lakh.
And what is their due?
The 45 lakh,
It transfers that in the e-auction sale, the respondent had valued the proposed property auction at rupees 45 lakh 41,701.19 based on 39,000 plus further interest and other charges. And it had fixed the reserve price at rupees 85 lakh. So it is the case of the petitioner that after realizing is the outstanding amount and other charges from the auction price, that is 85 lakh 50,000. There would be substantial the residual amount substantial and the petition has is a person who is entitled to receive a part of the state residual amount as the petitioner has already become an owner of a part of the property good property auction. The submission of the petition to for electric is not to be entered. Petition has further submitted that further that the bank should be guided. The Reserve Bank of India should be guided to disburse the that part of the digital amount is reasonably the petition. So the advancement of effect has law the pro- 7 the third has get that the money we pay the first and entitled according rights and
any part that you know, a person has established, right? And the people and the art is not proper to establish right, right so far as the right that such right that who are the response number 8 and 9, who was the original owner of the property and to determine such to establish such right so such right as number of disputed questions like all for conflict for establish for such right and such right and such right can establish on after only in a proper institute proceeding where party contesting party go forward in such a comma, very so as regard rapport of the decision is not found and that we have a system and
Whether I just give it to my, whether one
have a debate of it is however made clear that not entertain shall not take the petition to avoid appropriate debating as permissible under
I thank you.
to 20. There is no representation on behalf of MS R Boda and then NHI. One also, one, NHI teacher, one, 4 and 5. MS. You have not. Yes, Mr. Das, Mr. Mondo.
Because your lordship has
Speak louder.
got to get the
Okay. But what time? Say 30 minutes after.
5
Huh?
5.
Okay, in the meantime, we'll proceed with other method.
Lordship, in this matter, I am no longer representing the petitioner. I have written to the petitioner when he has received this notice,
Hmm?
I've been to the petitioner that no longer
Withdrawal notice.
yes, sir. To withdraw my yes,
Received by him or not?
yes, yes. The tracking report is there.
Third, Mr. E. Bora. Council for the petitioner, Mr.
K. Vishwakarma on behalf of Mr. S.P. Chaudhary for Union.
K. Vishwakarma, representing Mr. S.P. Chaudhary, Central Government Council for all the rest. Mr. Bora, by placing a communique addressed by him to the petition dated 16/2000 has submitted that he has sent a notice of withdrawal of the Okalatama to the petition. So, by referring to the track consignment of the notice, which has been sent by registered post, Mr. Bora has further submitted that the registered article containing the notice of withdrawal has already been delivered to the petitioner on 19/6/2000. Taking note of the above sum of Mr. Bora, Mr. Bora has submitted that the names of MS Mr. R. Bora, Mr. D. Bora,
Miss Arbora and
MS R.
MS Arbora.
and Mr. D. Bora. Be deleted as it deleted as the taking the and the contents of the notice withdrawal the to delete the name as well as the petitioner is not found represented by other civics.
My lord, if possible, if a date may be fixed, because there is an interim order which
interim order.
Yes, ma'am. There is an interim order passed on 4/1/7.
Okay, everything. Interim order for
Highly obliged.
Miller, in this case, Miller, the state was supposed to file the affidavit. But I have talked with the senior counsel, Mr. Talukdar. He said that
how much time?
17 minutes.
10 days.
10 days.
Lordship, a fixed date. I have no issue giving time.
Okay.
No, nothing.
Yes, no. For the HH3
One
for the and Mr. N.K. from Council for the 8 for the 2, 3 and 4. So the response number 3 and 4 has already filed an affidavit of Mr. Taluka waiting for the response has sought for an inconvenient bank filed affidavit on behalf of the number one. Fixing it will be difficult.
I leave it to your lordship, my lord.
Because no, there are other issues. This case is assigned to
My
and
lordship.
10 days. In 10 days, I'm not thinking.
And
I don't know when I'll. So please check it up on a date.
Obliged.
Sorry, my lord, actually, I am trying to that yes. So I
Ah.
just to meet up their quality
No,
made by your lordship.
no issue. It,
My lord,
there's no issue.
regarding that 17A, 17, how it is.
Three issues was
Yes.
one is how this page number so
Exactly.
is
It started in
Rule 18 as a schedule. Otherwise, we have to go by the
my lord.
rules as it exists today.
Exactly.
So, how it is connected? This
three, my lord.
Because joint registers are shown there,
My-
and these joint registers are from three different benches, and the table is
How
shown
it is incorporated.
how
in the
it
High
is
Court.
connected with
Yes.
Rule 11.
That, my lord, definitely there is some office order.
Definitely.
That time trying to file that
What is?
file, my lord. That is, my lord, I am unable to.
What is there? That is one.
And that is
That is one. Secondly, the zone of consideration which was taken into account on earlier
Earlier.
5 instances. Documents they have enacted.
Right.
Thirdly, 17.
yes. 7.
These three
17A,
basically
my lord. that-
broad issues.
And I am not asking for the amendment only. I am asking for how we inserted. 17A is inserted, my lord, in 1973.
Okay. And any orders exercising
my
that
lord,
power?
file, my lord. Still they are searching. Still they are searching. That is the establishment, my lord, is still searching.
Okay. That one. And connecting this stuff with Rule 11.
My lord.
And thirdly, the zone of consideration on previous 5 occasions.
Yes, 5 occasion, my lord, that already how it is.
No,
They have
if, if it is connected.
Yes, no, that is
No,
immediate position.
no, if these are connected with part of the rules under Rule 11,
My lord,
right?
my lord.
Then that is one thing.
My lord.
That is in conformity with the present situation.
Present situation.
If it is not,
My lord.
suppose hypothetically, if it is not, then other previous 5 exercises were in conformity with rules because on other 5 occasions they were not considered. Hypothetically.
Yes, that is that.
How and when it can be expected. And plus, 4, the presence thing which you are showing from the
My lord.
document, that can be brought in an affidavit.
That resolution. Yes, that can be. But
That this is the view of the court, of the committee.
I should also get a chance.
No, that is what I'm saying by way of an affidavit.
Well, I find, my lord, I have gone through it and rules also again thoroughly. I find it very difficult. How? Because Agartala, that Rule 11 is applicable. But by that time, there was outlying bench in Agartala. We were on the same, there's a principal seat.
So it is not
So, yes. Now,
deleted, but there is a constitutional amendment.
But my lord, but there are posts which has been created in Agartala. Your lordship has seen all the posts created in Agartala. Schedule someone 1-1 or 1-1D or 2D. Now the rule 11 so far is a common rule. But once you have a gradation list of in Agartala, it doesn't mean that Agartala, that person, say deputy register, he cannot come and compete in this. This I fail to understand. Now, there is one judgment I'll show Supreme Court, may not be so connected. The Supreme Court said that he was not born in the cadre. Somebody born in that cadre, because we have a gradation list in the principal C. A person, I have seen the date of birth also. Now, a person, example, in Arunachal Pradesh, who is a joint register, his date of birth is different, and the person who joined in register, his date of birth is different. So now,
Otherwise, subject to making it, I find too complex matter.
It's the same, my lord. I get that.
otherwise,
All
your lordship
My
is
lord.
right. Your lordship was right. Either they have to make a common gradation list. Everyone will have a chance. Then they have to change. Rule has to be changed. Then there has to be no gradation list. Now the problem, I have been told yesterday, my client has given Mr. Bormon, who's where I have shown my lord absolved. He has been brought back in the principal. Why? My lord, I am telling you, why he has been asked. State of Arunachal Pradesh is saying that we will not bear any pension benefit to, because he has not been absolved. How can we give? Because I think 4 or 5 months back, after 4 or 5 months or 6 months, he'll retire. So, my lord, where is the question of absolving him in that gradation list? He was not even born. That's why Supreme Court said that you are not born in the cadre. And yesterday, all will be affected here. Either your lordship is correct, put it, make a common gradation list. Then it will be.
You only addressing all the issues. Why did you file the comprehensive affidavit? Otherwise, on the present material available on record, right? The idea that not sufficient to. But I am interested for early disposal of the.
No problem. But regarding my lord,
Then because there are five, there are five. Because identify one is how this is connected with food land.
No, that I
Right.
take care of.
That. Secondly, the zone of consideration for the previous 5 occasions. Definitely you can bring in zone of consideration. I'm not saying that you tell the name, but who are the persons who are considered?
No, RTR occasion, what
Five, at least, no.
resolution may not
See, if rule is silent, then it will be replaced by convention and practice. If the practice on the previous 5 occasions is different from the one which is sought to be followed in the present case, we have to examine. Board has to examine. Am I clear?
Correct. That I understand. I got that.
Thirdly, how 17A power has been exercised till date.
70 something that my lord. I have like
That I have not seen. It is listed today before this court. I have not.
But if your
I have not yet applied my mind there because every time council is taking time, I have not seen any document of that case. So when it can be expected, but otherwise, I am interested in disposal of the writ petition.
That's true, but I because my lord, because of the shortage of the manpower in our when the basic intention of the filing the IS there.
But my submission before your lordship is that IA, if suppose your lordship decides the IA, and that will be that what he says, let it be subject to the outcome, so nothing will remain. So it is amounting. So my prayer is like your lordship has said to my learned friend that let him file a comprehensive affidavit, and your lordship can dispose of the matter. Whole matter can be disposed of.
This way or that way?
This way or that way. It may go against me also. It may go against
I
them.
don't know what will be the fate, but question is that the documents should be because there is some controversy and some ambiguity. Ambiguity. That ambiguity, at least the effort should be made to clear those ambiguities. Efforts.
Once for all.
At
Once
least.
for all.
But take time. To take time.
Otherwise,
It will take time. That's why, my lord, the main intention of the filing of this, my lord, IO is that is because your lordship kindly say there is a respondent also. But it is also, my lord, not third one of my lord, I don't know. They are private respondent. It is by the only employee association.
so you want an outcome of this I.
Right.
Okay, tomorrow.
He wants. And then I'll argue. Then he can't say 17A, then my lord. That's what my lord, your lord has made it very clear on these 4 points.
You want
4
My lord,
points
no.
without any affidavit.
Till now, I am searching, my lord, it is not that I am not getting it.
Okay, IA has been filed. Objection is filed.
Yes, I would have. Let it be on part. Yes, management cannot take the help of some papers giving it. But these are also important matter for us. Not
Because I
across the
cannot-
table. Yes.
I understand. No, say that place is that
This one. Anything?
possibly
You
ticketed
came
matter.
yesterday.
Yes, that I have.
Really? Oh, I'm not kept.
No, that is with me, my lord.
I had a look and
That I, by way of affidavit, that I can place. But all your lord, I can produce the record. But this, my lord, because I am yet to get the that query made by your lordship that it was incorporated. 17A was incorporated in 1973, my lord. 1973 file, my lord. I am passing, my lord.
no, I'm okay. Then how this power has been exercised? How many times?
No, only in case of my lord.
One. What is the condition there incorporated?
There is no condition. Probably he has taken back. He has been taken back, my lord. Probably taken.
I know the entire case, but I will not.
No, I
tell
was
what it-
appearing once, my lord.
I know the case. That I know, my lord, the Burman case, but we are not on that.
No, it is here.
That is the exigency of public service, my lord. But my lord, that is the order. Your lord, kindly read. That is
I have
also
got-
difficult for me, my lord.
I have got the order. I got the order also. This is the order.
It's the order.
There was exigence. There was some exigence.
Now, so your lord. I'm not-
17A, exigency was there.
Yes.
There was some situation.
Otherwise, for filling up.
My lord, I'll just humbly, because I am also in this High Court. I am also, we are always there to assist. Your lordship also a part of the High Court. Whether sitting on that side or your side. But that's why I requested my lord, we have to be very careful. It may not be so chaotic in every of the outlying bunches. We have to be careful. That's why your lordship is indicating. I have understood. Your lordship is indicating again and again. Because it will be, my lord, I am telling you today, my lord, I told my learned friend.
One instance for one case. 100 cases will not be jeopardized.
Yes, that's it. That's right. That's one. That's right. What I am saying that. My lord, I may lose this
Measures are there
I am
to
telling you
remedy
that-
such situation,
lord,
but
I am
it is not for.
But I am telling you, lordship, I may lose this case, but it should not lead to a chaotic condition of the High Court. That's I am telling.
Everything is dependent on the stand taken
Yes.
by Mr. Mohanto. That's all.
I'll
Meantime,
not be
I'll-
out of sick.
Then we'll go to Monday.
Only one request, my lord, let it be on Tuesday. One request Tuesday.
But it will be in the second half.
Second half.
At this
No,
time only.
yes. Your-
Because
that-
this bench will be sitting in division.
Yes, that's right.
So I can only pick in the second half. After business of the division bench is over. I
No,
can sit.
I also try to find out those things, my lord. Otherwise, it's
No, no.
difficult for me.
I understand your
But
situation.
I am handicapped.
And this court is also interested for early disposal of the
My lord.
entire issue. That is why I am.
I got the anyway, my lord. Okay, Monday, my lord.
Tuesday.
It is not only Mr. Mahanta, this court will be facing also.
My lord.
The petition has to be resolved.
No.
Exactly, my lord. Otherwise, everybody will be involved.
Yes.
Everybody is
Yes. We'll simply list on Tuesday.
Tuesday.
And
second.
3 o'clock.
3 p.m. We'll fix the date. Comma, is the case. Tuesday. Yes. Taken. Taken at 3. Yeah. It came on. Continue.
Deeply up.
3 p.m. Tuesday.
Yes.
And Mr. Mohanto, if you can supplement,
my lord.
please supplement.
My lord.
Not supplant.
My lord, yes.
On behalf of Mr. Dina for all the concern is not yet.
What is the subject, Mr. Rohit?
Well, this is regarding allotment of Bazar Vita. How long? Your lordship has disposed some matters with us.
Status quo.
Bazar Vita. Allotment.
Status quo already there.
In my case, there is not there.
Huh?
In other 27.
Perhaps because of certain reason, I don't. You are running or not?
No.
How much time? 2 weeks time. Okay. Who are the council? Mr. Rohit, you are in which item? 27.
27.
Who are in 26?
26.
Mr.
M.H.
M.H. Rohit, Learned Counsel for the petitioner in 26 and 9. Mr. A. Rohit, Learned Counsel for the in 23. Anybody from 28? And MS. M. Bormon, Learned Counsel Ina, Learned Senior Government for all that. MS. Subject that instruction. Complete instruction. I have not yet received. And has not sought for listing of the case of there are so many. This is the case after speak. The order of it fasting. Item 28.
26 and 29.
Specifically observed in the previous order that 106 crore.
Made it.
Yes.
Lordship, bill, Lordship, uh,
What is the controversy?
Lordship, they,
Here is time for
Lordship,
oh,
instruct,
non-payment.
non-payment of bill.
Non-payment amount of time. Yes, instruction.
I may put on behalf of SRF. The instruction is not civic time may be
One more few time.
Several
times.
Lordship already said.
4 weeks, 3
my
weeks.
senior said.
Huh? Four, five, okay. Okay, 2 weeks. Mr. H. Sharma. And Council Potter. How much is the amount?
99 lakh.
And Mr. Yes. Usami, you are there? Okay. Mr.
Yes.
E. Very Senate Council representing Mr. Yasa Dava and PC for 1, 3, 4. Yes, you are. Mr. N. Usami. 5. EB for as the standing of the Panchayat and Rural Development Department preparing for a response has sought further to extend to obtain instructions and fight affidavit in on behalf of
The team may be fixing a date.
Sorry.
The council appearing for this matter on leg.
Hey. Yes, Mr. Ahmed, what is the controversy?
Controversy is, my lord, a list has been prepared to provide houses under PMGY scheme.
They think from S.law.
Council will appear. On behalf of S.law, council on behalf of S.law.
Whether he is properly instructed or not.
We have filed it.
No, Mr. S.law is not available.
He is not available.
That council will replace or represent the doctor, he is properly instructed. If the time permits.
Allow further take this step to
Service of notice.
Yes, ma'am. That the purpose was not served.
RS. And concept of MDecal. Presenting practical. MDecal. As subject. Instruct. As regard. Service of purpose. I'm not getting what is the from the quick certificate.
Filing affidavit.
Yes, ma'am. Respondent number 5 has appeared or not?
No, he has received notice. I will complete my.
Which is
He had to file affidavit.
K. Sharma.
And for 3 and 4.
Yeah. 2 to 4.
2 to 4.
Mr. Sharma. Right. Order? 2 weeks. 2 weeks. Right. Okay. Oh.
Yep.
This is the last order.
Lord, on the last occasion, an issue had arisen before the Honorable Court with regard to the arbitration clause. If I may take your lordships to page number 58 of the petition.
$58.
58.
Hmm.
Clause number 45.5, arbitration, right at the bottom. Any dispute not settled amicably and in respect of which the DB's decision, if any, has not become final and binding, shall be finally settled by arbitration. I'll pause it for a moment, Lordship. This DB decision, DB stands for dispute board. The matter was referred to the dispute board. The dispute board gave an observation against me, and thereafter there is a time period framed as per the contract that if we do not agree with the decision arrived at by the dispute board, we can give our dissatisfaction within 2080. So we had given the dissatisfaction. Subsequent to the DB's decision, amicable settlement was tried, but that also failed. Now, if I may read further, the aggrieved party may approach the Indian Council of Arbitration within 90 days from the date of the decision by DR for settlement of dispute or difference by the sole arbitrator to be appointed by the appropriate authority of the said council. Now, my lord, the last day the dispute was, why have we approached the Honorable High Court for nomination of an arbitrator on behalf of the respondent and not approach the ICA? Lordship, mistakenly this particular communication from ICA, that's the Indian Council of Arbitration, has not been annexed to the petition. I'm providing a copy to my learned senior as well. Lordship, the Indian Council of Arbitration was approached in the year 2019, and by this email dated 21/11/2019, right at the top, Lordship. This particular email is from ICA Fiji. It was sent to the firm which is handling the matter of the petition. It says, dear sir, this is in furtherance to our 21st October 2019, seeking clarification from the claimant in regard to clause 45.5 of the contract agreement dated 13th March 2012, that whether the dispute between the parties relates to technical or non-technical matter. It is pertinent to note that according to clause 45.5 of the contract agreement dated 13th March 2012 between the parties, ICA has jurisdiction related to technical disputes only. Further, we note that for non-technical matter, aforesaid clause provides that where the parties do not agree that the dispute concerns a technical matter, both parties shall appoint one arbitrator and the two arbitrators shall jointly appoint a third arbitrator.
From your
Lordship, within quotes, the second paragraph of the email, first page.
Now they are quoting from this.
They are quoting from clause 45.5, page 59. Page 59, subclause 1, number B, where the parties do not agree that the dispute concerns a technical matter, the employer and the contractor shall each appoint one arbitrator, and these two arbitrators shall jointly appoint a third arbitrator who shall chair the
Yes,
arbitration
Mr.
panel.
Let me check, my lord. Lord will come to page number 12.
This is the same
12.
quoted there.
Arbitration clause number 145.5. That 90 days period is over.
Lordship, the ICA decision is of 2019.
Page number 12, clause number, they quoted the clause. And they say the party is approached the ICA have to approach it before 2019, and in between 90 days. And the dispute, the decision, the three-member dispute board has order has passed on 1/7/2022.
When DB decided
The final decision,
1/7/2022, page number
1/7.
2022. Page number is 38. My petition is 38.
DB.
Three-member dispute board.
Huh?
Three-member constituted dispute board was done, and
Page
380.
this was the third dispute board that was constituted. This was the third dispute board that was
final one.
constituted. Because the prior ones could not give a decision. The first one could not give a decision. Thereafter, second dispute board was constituted. But during the tenure of the second dispute board, one of the members was retiring. As such, this third dispute board was constituted, which heard the matter and gave this decision.
This is the final one.
The final decision says that right there is
Yes, Mr. Bro, have you filed your
No,
reply?
I have not
No
filed my
reply.
because this issue has come in, my lord. In the meantime, I will file my affidavit. And
Because
at the same time, my lord,
they have approached at least.
my lord, this may be brought on record, my lord, so that I can be complete.
Thing is, by spot affidavit.
not then it's 2-3 weeks time may be granted. Yeah, I'll try my best to file it earlier.
But then when has come, that's not part of record.
Since this was according to last order, so today only I could. There was no
Okay.
fixed date.
Heard MS?
P. Agarwal.
Yeah, good. Got it. Got it. And Mr. S. Got it. On it. Got it. What about technical?
Good.
EMT order respondent.
Hold on.
On the previous date of comma an issue regarding clause 45.5 had the right in as clause 45.5 of
Particular condition.
the has literally contained that a party agreed by a decision of the dispute court can approach the Indian Council of Arbitration within 90 days from the date of that dispute. MS Agarwal and council appearing for the petition has submitted command instruction command that the petition had earlier approached the Indian Council of Arbitration in the year 2009. And the Indian Council of Arbitration, by its communication dated 21/11/2009, had verified that since the dispute between the parties related to non-technical matter, the Indian Council of Arbitration did not have any jurisdiction over the matter, and it was opined that the matter will be covered by that part of the arbitration clause where it provided that where the parties not put on Peter Esme, MS Agarwal has submitted that the same would be brought by way of petition within a period of
2 weeks.
Mr. Bora has submitted that such addition leading evidence submitted in week, he will make an endeavor by counter comprehensive in the field. When he got submissions, but 4 weeks. If file 2 weeks, when is a copy, he'll try to file counter.
Sorry. Keep your pen.
Item 37 lordship. I thought with instruction.
Oh. Yes, FI I can. Yeah. Very good. Yes, how much time?
2 weeks.
2 weeks. 2 weeks.
This case lordship sanction has already accorded.
31st October 2000. Do you have any instruction? No. You have the telephone number or not? Bank telephone number is available with you or not?
Available, but
Take a call, find out. Look, it's 7 months back. Take up, otherwise we'll close. Not make the exercise of listing the case again. Find out. Take a copy from
have been if there is a second petition affidavit on number 3, we have filed some RTI reply. This reply was not started yet.
Huh?
We have applied some RTI applications regarding this matter, but they have not yet replied. So
Last time.
we
This letter not putting to RTI reply not providing them. This city versus duty letter matter.
if RTI is relating to our case.
Whatever. The petition is not cannot wait for
Yes,
receipt
Lordship,
of
we have
standard.
on 24 4 2024
Whatever.
we have filed.
Follow up in appeal.
No, Lordship, on 24 we have 24 April we have filed our affidavit, but it is an affidavit.
Huh?
On 24 4 2024 we have
Petition.
filed
Then
affidavit. Reply affidavit.
one affidavit in opposition filed. Then additional affidavit filed by whom? Respond number
Addition-
3.
Respond number
Lordship,
3
we have
and
filed.
Then
bring on record.
additional affidavit in reply filed by petition.
Reading complete matter.
Incomplete.
No.
You
no, no, Lordship, on it is an affidavit we have to reply.
Huh?
It is an affidavit filed by respond number 3 and that we have to reply.
Lordship, my lord may kindly have a look at the additional affidavit filed by the GPO Lordship. On this,
decide whether because you filed a affidavit in reply
Reply.
in 24th of April, right?
And Lordship,
Whereas the affidavit in opposition was filed in February and additional affidavit was filed in March, right?
Yes.
Taking more than 45 days time from the date of filing of the additional affidavit, you had filed the affidavit in reply after 45 days from the date of filing of the additional affidavit. No. Now, where is the question of
Lordship,
not filing? The petition was filed on 2nd February. Affidavit was, additional affidavit was filed on 27th February. Additional affidavit in opposition was filed on 12th March. And after 45, you filed your affidavit in reply.
Lordship, in their edition affidavit, page number 131, running page, annexure M, and that we have to reply. That's why we have filed.
What is so important about annexure M? Page
131 matter.
why it is important? What?
Lordship, my lord may kindly have a look. Lordship order dated 7/2/2024. 7/2/2024, because I have argued regarding the maintenance of the petition, my lord. And paragraph 12, my lord has observed.
Now what?
Yes. And Lordship, we have our reply to annexure M. Lordship, we have filed our RTI on 11/3/24.
RTI, I don't know.
No, no.
RTI. For RTI, I don't say about that. You're not
Collecting information of
for RTI.
admittedly. But to reply this
Petition is
annexure M.
not to be dated
Yes.
for receipt of reply of RTI.
Yes.
RTI authority has not furnished her first and second and it kept pending. So that is not the
But still, we have tried, but if they have not provided the document, then we have to take another step. So, Lordship, that is 2 weeks. So that we
not 1 week.
Lordship, may I submit the present status of this case? Ever, Lordship has given us liberty to reroute their vehicles passes. We have issued personal notice. 50 of the owner has already taken NOC for cancellation of their permit before institution of the repetition, but they have said 200 members of passes. Before institution of repetition, they have taken their NOC. And after our Lordship order, 10 owner has already rerouted their passes. Some of them are still sitting, but they have just minor order.
Complete your instruction.
1 week.
Is partially
Mr. E. Sharma.
Yes, sir.
E. Sharma. Got it. Now, put up. Spider. 110. 5. It is generated. Afraid of the fire. On the ground. In paper.
so deeply of the
The interim order is 5.
Lordship,
7.
we have already first got the happens after minor order.
The interim
Deeply of the
Your Lordship. Lordship, in this matter, the respondents are required to file their FLF.
Yes. How much? 3. Huh? 3. Where?
Them come with the affidavit.
Interim orders are passed. Mr.
S. Gautam, Your Lordship.
S. Gautam. Yeah. Avenue 1 and 4 on and 8 and 3 here 10 by the concept. Right. Password.
Pleasure.
Anything? I need
My lord, they ought to have given me at least a copy of it, but I understand whatever it has been told to me about the contents. As per my information, after recalling him over here, the committee is waiting for the disposal of the writ petition. So, my lord, I only wonder what for the disposal. The committee itself could have constituted the review DPC. The law of the land is very clear.
No, I have not looked at till this point of time. I have not looked at any single paper because everything was going on. Now he has come back.
He will be joining, I was told, on 23rd. Because they have not yet released him from Itara.
Look,
yes. They could have given to me earlier. These are not secret.
Already notified. Maybe in the website also. Portal. Portal uploaded perhaps.
That's it. Not waiting for the disposal of the writ petition by this honorable court. The law of the land says, if I am exonerated, no departmental inquiry is pending against me. If I was denied the promotion, the review DPC is to be constituted. And in this case, I'll just give the list of dates. I'll just show the date from which the review DPC is to be constituted. It is 24/9/2009. Lordship will just have a look at that. 4 dates, Lordship will just. Since then, the drama, one after another. There have been 3 departmental proceedings. First 4-5 dates, Lordship will see, that's all. 21/7/2003, promoted as Deputy Registrar at the principal seat. 16/11/2005, serving as Deputy Registrar, placed under suspension. 23/6/2006, charge sheet issued. 18/12/2006, major penalty of reversion from Deputy Registrar to Junior Most Assistant Registrar. 24/9/2009, his immediate junior gets promoted to the post of Deputy Registrar. Sorry, was promoted to Joint Registrar. Then, my lord, on 2/3/2012, the division bench quashes the order of penalty. So, my lord, on 24/9/2009, his immediate junior in the cadre of Deputy Registrar was promoted as Joint Registrar. So, as on 24/9/2009, the review DPC is to be constituted and has to consider risks. Since then, my lord, 2 more departmental proceedings, exonerated in both, kept in Itanagar all throughout. And my lord, Justice Lama, my lord, in the last order which he had passed, administrative order, the observation was Itanagar needs a person like him, highly experienced. And to show that there is a scarcity of competent officer in Itanagar, example was given of Mr. Datta, that Mr. Datta was also initially brought to Guwahati but was sent to Itanagar. It was reflected in the order of my lord Justice Lamba, which is the annexure, my lord, in the writ petition. And interestingly, my lord, immediately after the order, Mr. Datta was brought to Guwahati. And still he is in Guwahati. So intention is very clear, but my lord, in a temple of justice, the justice has to be done.
Very possible today.
To Lordship has seen it, so that's
And we have to decide it now. There is no other way.
No other way. They have to do it. In Agasti will retire. Agasti will retire.
document will be available.
My lord, the only difficulty is, my lord, from next week, in outlying bench, there are lots of cases.
This court has also
So for 2 weeks at least, my lord.
for 2 weeks also for court. It will be
So
equal
after 2
division.
weeks, after 2
Yeah, fix the date. We don't know how long I'll.
So after 2 weeks, lordship may give it. After 2 weeks, commencing from the Monday of the next week, 2 weeks.
Here to. Go on here.
For admission hearing, otherwise.
No, I know because this matter will be listed for me only. It will not go anywhere else.
I know, that's why.
In a week commence on a date. In a week commencing from 3rd of 2 weeks. 2 weeks. Any day. In the admission court. Public. Already faced, I have said. He's already uploaded it to our website. But because it purchased the
My lord, in this case, I am appearing for response number 3 and 4, my lord.
Yes.
I have received some instruction, my lord.
Sub instructions or full instructions?
Some, my lord, duty election proceeding executive officer. My lord, on my lord, 26/12/2022, principal report is a complaint from one Gol Kishore, my lord, Ivan Krishna Kundu. Number 1, I have that much.
What is the issue? The service of notice did not. Now, why it has come?
For admission, no, the service is complete, my lord. Admission column.
So what is there? You have to
My lord,
They have raised a plea that for repairing work,
yes, but
no NOC is required. That is the issue.
my lord, municipality stopped the construction, my lord, renovation work because of complaint filed by one Ibon Kundu.
Now, what is your
As per his allegation, he has not sold any property to Mr. Umit Acharya, and as per his real method, he has purchased the building portion from Umit Acharya. That is a difficulty. Accordingly, we filed a petition before Sub-Registrar Dhubri matter for clarification of deed, both the deeds. Flag, yes, flag 2, my lord. What you may kindly go through the flag 2. Senior Sub-Registrar Dhubri requesting for furnishing a clear clarification against the 274 269. My lord. As per their claim, my lord, they have
raised their
yes.
Their
They are claiming
it is part of the
yes, yes. They have
now what? How long?
My lord, reply of the Sub-Registrar may kindly see flag 3, my lord, to the executive officer Dhubri Municipality Board. One deed they have found, my lord, genuine, but the deed which is under which they are claiming that they are the owner of the portion of the building is not found, my lord. Which refers to the subject and data cited of, I have the honor to inform you that it reveals from this office record that deed number so and so could not trace out.
No, for 6 years you did not raise anything. But that was in 2016. They said they purchased it by Mr.
Yes.
In 2022.
But
that is genuine.
My lord,
that is genuine. Who are you to inquire into that?
Otherwise,
who are you? Municipal.
Municipal. I have authority.
What authority you have to inquire?
Before
make a complaint for the proper authority.
Giving permission, my lord.
Doubtful. We have some doubt.
But even then, they have not taken any permission from the municipality.
That is their contention. No permission.
Permission.
You reflect that.
Anyway, I will.
Where you are digging some other hole. Their contention. They have.
Yes.
Now you are making investigation. In my investigation, you have found that their research is genuine. Right?
No, their research is not genuine. Other.
Mr. Come to Pera. Come to Pera. We read the report. We read the report. Okay, come to Pera.
Yes,
you call to party. And Krishna party. Petitioner. Petitioner.
Yes.
Pera 2. Husband and wife.
Yes.
And purchase the flat.
Flat.
First floor. Right?
Yes.
By register next page. Third line. Register cell deed number T1 from Omitava site. Now take your instruction. Senior service. Next, fourth line. The deed number showing. Maybe they are wrong in the deed number.
Yes.
Which was executed by Omitava site. Member of Jukal Party and Party has been found to be genuine and authenticated. What more is required?
But I have not told as per allegation, Ivan Krishna did not sell the property to Omitava site. The first part, my lord, the data, yes, which is not found.
They are not concerned with Jivan Kundu. You make investigation 100 number of investigation. You can do, but so far this treatment, whatever is required, do such. We are not concerned with unnecessary. Anyway, this municipal board is not the authority to examine. You may make a complaint.
Yes.
Other than complaining authority, you are not the competent authority to examine the Now next question. They are saying they don't your market. What is your
Other give me some time and
and then you have wasted minutes of good time. Yes, sir. And it is the PS council for one number 2 3 4 right. Yes, sir. So far as whereby the that from 3 from its archival owner. Yeah, omit of site from genuine as spoken by the doctor to be. Yes, that for other as regards the great good body of the Assam divided urban area and other than affected is the doing keeping prayer for keep for of
Dead people. Below, otherwise below last talking.
I am not we have filed a affidavit. Filed a affidavit.
Hello, there. Actually, there. The authority has.
What is the stand here?
Their stand that
You are claiming
different stand they have taken.
Huh?
Different stand they
not
have
a
taken.
clear cut stand.
No, illogical see. Page.
And Mr. Ahmed, it be difficult for
today.
Next witness day. So yeah. You shall not get that. Okay. Uh, yep.
Next week.
Next week. Hello, sir.
Maybe. Because as per my telephone inspection, they is not received it. And so far as my inspection provided, it is the sanction amount. Only the sanction.
We forwarded.
Yeah.
Parcel process might have been completed already 7. Do it. Uh, Have you read? We are reading you.
But I
Read.
sanction
Read and explain the meaning.
the sanction has already been accorded for an amount of tax respect the Florida state of the
Where? This
and
is not
forwarded to revenue and disaster management.
no, what notification date? Date? What is the notification? Date. You have placed it. Huh? Who has placed?
Not within Canada.
It is the okay, Mr. Gustami and Mr. Mohan. Sanction is accorded or what?
They do forwarded, yes, sir.
Huh?
Sanction has already been accorded and forwarded to the
Sanction is accorded by who? Mr. Gustami has submitted command track that an amount of rupees 2 lakh as sanction for an amount of rupees 2 lakh has been accorded from the end of the district commissioner Ojai Bojali and matter has been forwarded to the revenue and disaster management part for what? For disbursement of the amount the benefit. MS quantum for an extending of it. That's what the opinion. Money has been disbursed to the beneficiary. Few of the inside for the board has become service of basic.
May it please your lordship.
Yes, what happened? We just want to yes, instruction. But response number 9 is served. Hmm? Served. notice has been served. You are appearing for whom? Huh? For all. Are you clear? Do you have the brief? You are appearing for whom?
Corporation Department on behalf of the Department.
Huh?
Corporation.
Where is the portal? How
My
can
lord,
you represent everybody?
my lord, we need 2 weeks time to file our reply.
You have filed affidavit.
Okay, file it. No number 4 file.
Mr.
R.A. Pramanik.
F.
R.A. Pramanik.
Order. NMS. Direct Contact. Corporate Department. Right. The service. Nine.
My lord, date में
Page number 14, annexure A is the order dated, my lord, 21/8/2023.
Paying for the respondent lordship. As per my telephonic instruction lordship, the order is duly complied.
Right.
So lordship, therefore, after 3 weeks, I may be granted by my activity. Everything on record.
No, my lord, no, my.
Okay, you reserve your no, but he is submitting an instruction that order has been complied. Complied with.
Yes.
He is submitting an instruction. I'll record that.
Yes,
Telephonic instruction.
So what harm? Don't say no right now. And he will bring this by way of an affidavit. So I'll be recording his submission.
Yes.
And you follow up, find out
My lord.
whether order has been duly complied. And you come up with your second contempt application.
My lord.
Right? Heard. Mr. D.K. Board.
Yes.
Senate Counsel for Deputy. And Mr.
R.S.
Rongha. Senate Counsel for the Respondent. Mr. Rongha. Quite few is then. Order is complied. Order is passed. Is it done? Across the counter,
2 weeks, as per my instruction.
have submitted. Come on, instruction, come on. The order dated 21/8/2023 has since been complied. So he has, however, wait for 2 weeks time to file the affidavit on behalf of the respondent. The prayer, if I out, after 2 weeks for filing the affidavit by the respondent. Good one.
Lordship, respondent 7 has
Went. Yes. Which 7? One number 7. All. Yes. Third is
B. Shah.
B. Shah. Senate Counsel for Deputy. NMS
Jayapura,
Jayapura, representing as also.
Lord.
Standing on. 1, 3, 4, 5, and math. Right. Okay. What's that? Do you think?
Lord.
Right. Readings. Right. Same order of yeah, sure.
Whether we have filed paper which are bearing the picture. So I will file additional affidavit in our IA.
Your
Yes.
which is
My
your
IA is 925.
925.
But they have also filed an IA, copy is not furnished to me.
File.
Maybe I have another copy.
File affidavit.
Yes, in IA for vacation of the entry report.
How much time?
One next week.
I yeah, it will be filed within 1 week. Yes, that's what I did I thought after the for the now accepted release the case. Thank you.
If the next day they do not appear, then
For instance, it is
This matter, pleadings are complete, my lord. The respondent number 4 has also filed affidavit. Service is also Section 14 matter, my lord, for taking.
the time is not
It may come for admission, my lord. Any case.
Ganguly for the people.
I
Who are for the respondent?
I pro one
Okay. One minute. Mr. DJ uh, as per order 5 of the Rajma Code, the service of all the respondents are served is the case for anything that some other
But I just for 2 weeks time find out
which one?
is 49. Impeachment I
1280. It's the D board. Petition and Mr. Council for the private for your petitioner in 49. Helen Tapati, you are 40.
Yes.
Morua, you are 8. Mr. S. Car. Then council for the by
4 and 5.
Mr. Vinaya. And the PT, Mr. Tapat. Then for the opposite party. Yes, I number 1 8 2000. Five object very